Thus, upon due consideration and having heard the learned counsels for the rival parties, I find no merit in the writ petition, and accordingly the same is dismissed. No cost. Wait. Yes, wait.
My lord, item number 22, my lord, motion matter, my lord. There has been subsequent development, my lord. Another impugn order has been passed. So I seek liberty to withdraw.
22, I think. 21 was judgment.
22, man.
Yes, 22.
Yes. For withdrawal with liberty, my lord. We filed today itself.
All right, Mr. D. Pangin, learned counsel for the petitioner, submits that since there is some recent development, he may be allowed to withdraw the writ petition with liberty to file a fresh. Stop. Prayer is allowed. The writ petitions that's dismissed as withdrawn with liberty to file a fresh, if so advised.
Oh, brother.
Your Lordship, I beg to make a mention for today as an unlisted item, Your Lordship. I have some urgency in this case.
Motion.
Motion unlisted for unlisted.
What matter is it?
Your Lordship, my land possession certificate has been cancelled by the Deputy Commissioner without having any authority of law. This is a matter of jurisdiction also. Without any jurisdiction. That is a nullity order.
Question is, what is the urgency?
Lordship, since my LPC has been cancelled, Lordship. Now it may be that I may be directed to vacate the land which I was possessing on the basis of the LPC. So that kind of urgency is there. So that is
when was it cancelled?
This 1 August 2000.
1st August.
1st of August.
When have you filed the writ petition?
I have already filed.
When?
This morning. It has been filed. So,
Did it come up tomorrow? We'll see.
all right, Your Lordship.
Tomorrow.
All right.
My lord,
Yes.
I'd like to mention item number 2 and 3, my lord. Earlier, my lord, this case was led by I. Choti, my lord. Senior counsel I. Choti, my lord. After his appointment as a AG, he could not proceed the case anymore, man.
Who?
The senior counsel I. Choti, man. Earlier,
I see.
yes,
So that, I think that was already reflected in the last order also.
yes, man.
So till now, there's no arrangement.
No, man.
How long can we wait? How long should we wait? You
Yes.
tell me,
Yes, my lord.
within what time can you make the alternative arrangement?
Yes, my lord. Then, my lord, some fixed time may be given, man.
You are,
Fixed date.
you are there in the case?
Yes, man.
What is your good name? What is your name?
Dia is my lord.
Diado.
Yes, man.
2 weeks will be suffice?
No, sir, 2 weeks may be given.
All right.
And Meta takes on the 6th of September.
You want a fixed date?
Yeah.
Why? There's an urgency?
Yes.
Any interim order?
Interim orders.
Please write down Mr. D. Ado, learned counsel for the petitioner, submits that Mr. I. Chaudhary, learned senior counsel, has since been appointed as the Advocate General for the state. And therefore, 2 weeks' time may be granted to the petitioner to make alternative arrangement. Full stop. It is seen that same submission was made on the earlier occasion as well. Full stop. For ends of justice, further 2 weeks' time is granted to the petitioner to make alternative arrangement. List the matter again on
May I please, Madam? Councillor Armais.
the others. When do you want it?
My lord, list after 1 week. Yes, madam.
Okay, similar order, make it 1 week this time. Huh?
Leave the blue.
May I please, your lordship,
Yes.
I would to mention, your lordship,
19.
here the state has already filed, they have affidavit
Hmm.
in opposition. Against that, I'll have to file one reply, your lordship.
How much time?
1 week, your lordship.
All right, as paid for by Mr. A.K. Singh, learned counsel for the petitioner. A week's time is granted for filing rejoinder affidavit to the affidavit in opposition of the state respondents. To establish the matter again after 10 days.
Lordship. Much.
Yes,
May I please, Lordship? Lordship, I beg to mention item number 6 and 7, 6 and 8, Lordship. On behalf of Tijama, Lordship. Here, Lordship, we have to file, your Lordship, affidavit in opposition. So, Lordship, we are waiting for instruction from the department, Lordship. So the matter may be listed after 2 weeks, Lordship. And in the meantime, Lordship, I have taken consent from the other party, Lordship.
before that, it's item 2 and 3, no? Just check up again, 2 and 3. You write interim order fast to continue till the next date. So have you informed the other side?
Lordship.
Mr. Singh is there.
Lordship, I am for the petition.
All right. How much time do you require?
Lordship, 2 weeks,
2
Lordship.
weeks. 2 weeks? As paid for on behalf of Mr. T. Jamo, Learned Standing Council, Education Department. Further 2 weeks' time is granted for filing counter affidavit. List again after 2 weeks. Item 6 and item 7, similar order.
No, Lordship, 8, Lordship.
I'm
Item
sorry,
number 8.
item 6 and 8. 6 and 8.
Duly acknowledged.
Yes,
Your Lordship, this writ petition has been filed to challenge the impugned NAT plotted by the Executive Engineer Pasigat on 22 June 2023, Your Lordship. The copy of impugned order has been placed in annexure to page number 48 to 162, my Lordship. My Lordship, I came to know about the said NAT after the last date was over. Your Lordship, it was not known to the eligible bidders other than all those 4 participants, Your Lordship. Your Lordship, I am also a taxpayer and a bona fide citizen, as well as the prospective eligible bidders. My farm license has been placed in the Annexure 1 and Annexure 1A, page number 45, Your Lordship. Your Lordship, equal opportunity was not afforded by the respondent authority. This is strike Article 14 of the Constitution of India, Your Lordship.
no, see, this
Yeah.
NIT, how was it issued? It says NIT,
Yes, e-tendering. Your
e-tendering.
Lordship, yes.
so it must have been on the website.
Your Lordship, it is but mandatory to publish in the newspaper, Your Lordship. As per the clause, Rule 161, clause 3 of the GFR 2027. Your lordship,
Sorry, you are saying some provision. What is that provision? Rule
GFR 2017, Rule 161.
GFR,
Yeah, GFR
GFR
to 2017,
2017,
clause 3, Rule 161, clause 3,
Rule 161.
clause 3, my lord. Yeah.
Have you enclosed that in your repetition?
Yes, my lord.
Where?
In
Where is it?
Annexure 11,
Page?
page number 121 to 226.
121. Page 121.
Oh,
121, I think it's a.
oh, no, I'm sorry, pardon, 221. 221.
Two 21 GFR.
Yes.
And the relevant page is at 161. 222. Advertised tender inquiry.
Yes, Lord. My lord, the Rule 161, clause 3 reads follows, my lord. Advertisement for invitation of tenders should give complete web address from where the bidding document can be downloaded.
Hmm.
My lord.
So
My lord, by
can be
following,
downloaded. That means it talks about e-tendering. It talks about e-tendering. Download. It's not saying where
well,
it can be
my lord,
purchased.
this e-tendering, even though e-tendering from, it should be given in newspaper that from where and in which website the tender document can be downloaded, my lord. My lord, by following this GFR 2017, this Arunachal Pradesh Public Work Department has plotted ENIT through press publication. My lord, in dated 11/12/2018, Executive Engineer PWD Tali has also published e-tendering in newspaper, my lord. And even in 25 May 2023, a whopping amount of 98.98 crores was published in newspaper by Executive Engineer PWD Tali Division. And my lord, in
No,
dated
just-
2020,
Just a minute. Just you come to the 161 clause 1. Page 223 only. 223.
— 161.
223, page 223. Have you got it? 223.
Yes.
223 on top of the page, you just from the 5th line. 6th line, in fact. Advertisement in such cases should be given on Central Public Procurement Portal, CPPP,
Yes.
at W so and so, and on GEM. An organization having its own website should also publish all its advertised tenders inquiries on the website.
Yes. But
So
mm,
it will be published in the government website only. Where was it published? This NIT,
this NIT was published in 22nd June 2016
correct? But where? In the government portal.
in government portal, my lord.
So you're not aware of that. You are a contractor,
Yes, my lord.
class 1A,
Yes, I'm a class 1A.
class 1A. So you
Yes.
should be knowing.
My lord, nobody knows other than only these
Huh?
4 participants, my
No,
lord.
you should be knowing about the government portal, all that, since you are a
Yes.
contractor,
Your lordship,
isn't
in,
it? Isn't it?
yeah,
Everybody, all the public may not know, but at least you are a contractor.
yes.
You want contract work, so you'll always be on the lookout on the government
Mm.
portals that what is the advertisement, what tender is being called. So
Mm.
how is it possible that you did not know? Your basic case is that you did not know because there was no paper publication.
Yes.
Is it compulsory that they have to publish in the newspaper and
Ye- Yes, my lord, in
Huh?
CPW manual 2014,
where?
annexure 8, page number 192 to 195, my lord.
192 to
192 to 195,
CPWD manual.
yes, 2014.
Where is the relevant provision which says that?
Wide publication should be given to the notice inviting tenders,
From where are you reading?
page number 192,
92.
yes.
No, 192 is the first page. CPWD Works Manual 2014.
Yes. But, and 193, section 17, my lord, 193.
Yes. 17.1. Are you reading 17.1? Wide publicity.
Yes.
Read.
Wide publicity should be given to the notice inviting tender, form CPW 6. Tender must be invited in the most open and public manner possible by advertisement in the web as well as press. And by
No, not
notice
as well as. It says website / press.
Yes. So it should be given in newspaper as well as in web portal, my lord. It should be given in, first of all, it should be given in newspaper that is stating that the NIT has been plotted and you can download it from that website.
No, where is that newspaper thing? I've not found any newspaper.
My lord,
By advertisement in the website
Yes.
/ press.
yes.
So it can be either of those.
Both are mandatory, my lord.
How do you say that? If it's mandatory, then the language will be different, isn't it?
Hmm,
Website as well as in the press
yes.
by newspaper publication.
Hmm.
Then
But-
you can say it's mandatory.
Yes, first of all, your lordship, it should be published in newspaper and telling that in that website, we have uploaded the tender document from, you have to download it from that website, my lord. And it is the general practice of our, every executing agencies, engineering wings of government of Arunachal Pradesh, my lord. In, my lord,
See, general practice is one thing.
yes.
General practice is one thing.
Hmm.
In some cases, you may not practice that. Now, the question is it mandatory to publish in the newspaper? You are saying it's mandatory. When I ask you to show me where is the provision, you show me this provision. Out here, it's nowhere written that it's mandatory that it has to be in the newspaper.
My lord, in notification dated 30/1/2018, we published by the Director of Information Public Relation Officer,
Where?
Government of Arunachal Pradesh. It is written there. Newspaper publication is mandatory.
Where is that? Where's that?
That is in annexure number 13, page
Page?
number 142.
142.
No, 230 to 241. Relevant clause is in 239 page number. May I read this?
Just a
Close,
minute.
my lord.
You were referring to page 200 and
139,
139.
yes.
139.
This is the notification issued by the Director, Department of Information and Public Relation Office, Public Relation, Government of Arunachal Pradesh, my lord.
No, 139 is something else.
One, this is guideline, my lord. 239, your lordship.
You have missed the thing, misquoted by 100, difference of 100 pages. 239.
Yes.
Guidelines for issue of
Issue of government advertisement,
2018.
clause 5, my lord. This,
Five,
this
yes.
notification issued after GFR 2017 was amended. GFR was amended in 2017 and this notification is of 2018, my lord.
Mhm.
In clause 5, any advertisement, display or classified shall be issued to more than 3 local dailies. While issuing advertisement, particularly tender, all department need to follow provision under GFR for maximum publicity. One national, regional daily, as the case may be, included on requisition from the concerned office, department, or as deemed paid by the Director of Information and Public Relations. My lord, the restriction shall not apply to advertisement of general nature issued by DFR on a special occasion of importance which prior administrative approval is obtained. In case of clause 6, in case of cases where department want their advertisement to be carried in certain newspaper on the ground of maximum possible publicity and reached in the intended targeted area, advertisement will be released as per their requirement in one chosen newspaper, in addition to issuing same another newspaper as the per roster basis. This made mandatory to publish in the newspaper, my lord. This is the Department of IPR is regulating the government tender, my lord. Any government advertisement, including the notice inviting tender of any government role within the state of Arunachal Pradesh. This rule has to be followed by the department, your lords.
Advertisements are normally published in which paper? Local dailies.
Yes.
Where is it published? In local dailies.
Local, it should be published in two national newspaper and 2 local dailies, my lord.
2 national newspapers and 2 local dailies.
Yes.
Okay. Now here there's a restriction in this. Any advertisement, display or classified shall not be issued in more than 3 local dailies.
Yes, my lord.
So this is austerity measure. Instead of publishing in all the local papers, they say that maximum 3 papers, isn't it? Is that the reason why these guidelines have been given? Shall not be issued to more than 3 local dailies. You are saying 2 national, 2 local. Where is that?
Minimum, my lord, it should minimum 2 local dailies. 3 is the maximum and 2 is the minimum, my lord.
Where is that? I've not seen that. Clause 5, does it say like that? 2 local, 2 national?
Not more than 3 local dailies. This is
It says
maximum
not
limit.
more than 3.
3.
But you were saying it should be 2 local, 2 national. Is it provided anywhere here?
Limit of selection of newspaper is not provided, my lord.
No,
Huh.
not selection of newspaper. I'm talking about
Yes, publishing. of
1 or
newspaper.
2 or 3.
Yeah,
It says that should be not more than 3.
yeah.
It does not say it should be 2 local and 2
But
national.
as per the law is the common understanding, your lordship. It should not be published in only 1 local daily. So it should be always published in any kind of notice should be published in 2 local dailies, my lord. This is a general practice, my lord, as law understood, my lord.
Mm.
Even this Honorable Guwahati High Court has upheld this notification in many cases, my lord.
Mm.
My lord, reliance could be made on page number 33 of the petition, my lord, para 34. Page number 33, para 24. Your lordship, in ML Enterprise versus State of Arunachal Pradesh and others, 2018, 2 GLT 269, the Honorable Court held that in awarding contract, state action should be fair and tender should be invited by advertising the same in well-known newspaper. Otherwise, the violation of the same is hit by Article 14 of the Constitution, and the award that contract is liable to be set aside. The operative portion of the judgment at para 46 is that as follows. With regard to the distribution of state largesse or government contract, it is well settled that a statutory body and instrumentalities of the state should act fairly by making it open for all eligible to submit their offer, and the awarding of contract without inviting tender cannot be said to be fair. And any such contract is liable to be questioned. Contract by the state, its corporation, instrumentalities, and agencies must be normally granted through public auction, public tender by inviting tenders from eligible person, and the notification of the public auction or inviting tender should be advertised in well-known dailies, my lord, having wide circulation in the locality with all relevant details such as date, time, place of auction, subject matter of auction, technical specification, estimation, court, earnest money deposit, etc. The award of rock contract through public auction, public tender is to ensure transparency in the public procurement, to maximize economy efficiency in government procurement, to promote healthy competition among the tenderers, to provide fair and
All right,
equitable
all right, all
treatment.
right,
This is what
all right.
this one.
What else? What else? We have referred to CPWD manual, then you have referred to the notification of 2018. And now we have relied upon this 2018 2 GLT. To contend that there should be wide publicity and
Yes.
it should be a newspaper publication.
Yes, this what this honorable court has said, my lord.
Now,
My lord-
what is the stage of the tender?
My lord, this tender financial bid was opened on 9th August 2000. Financial bid result was opened on 9 August 2023.
9
it-
August. Okay.
Yes, and respondent number 4 has been awarded as L1. My lord, even according to by virtue of the court judgment, even already awarded work have done already awarded work has been started, and some portion of the bill has been paid. That work was also set aside by this honorable court. In this instant case, my lord, the private respondent has nothing to lose because they are yet to incur any losses. Work is yet to be awarded. NOA is yet to be awarded, my lord. So this is liable to be questioned, my lord, this NAT, this
So
imputed NAT.
on 9th of August, the financial bid was open
Yes,
and now about almost 2 weeks have got.
yes.
What is the latest position?
My lord, this is,
Don't know. Work order has not been issued.
no, yes,
No,
work
not issued.
order not issued, my
Not
lord.
issued.
Work order has not been issued, even no agreement, no bank, they have to deposit 10% gain. According to bank grantee, they have to deposit 10 crores, 10% of 99 crores, my lord. That has not been done, my lord.
Otherwise, are you qualified to participate?
Yes, my lord.
You're qualified.
Yes.
Who can participate for the tender?
My lord,
Contractor,
in case of Arunachal Pradesh Contractor Enlistment Rule 2008,
Ah.
Class 1 AA can participate in the said NIT.
you are class 1 AA.
In case of in Assam,
Ah.
Class 1A is equivalent to Class 1 AA of Arunachal Pradesh, and I am a Class 1 enlisted contractor in Arunachal Pradesh, and Class 1A contractor enlisted registered contractor in Assam,
Hmm.
PWD building wings, my lord.
Class 1 in Arunachal.
Class 1 in Arunachal, Class 1A in Assam.
Assam.
And Class 1A in Assam is equivalent to Class 1 AA in Arunachal Pradesh,
Okay.
my lord.
And who can participate here? Class 1 AA.
Class 1 AA who is being registered in Arunachal Pradesh Public Work Department,
Hmm.
and Class 1A from Assam.
Where is that? Class 1A from Assam.
My lord,
Is it available in the NIT? Or
NIT?
IFB? Whatever.
no,
you
it
call
is not mentioned, my
It's
lord.
not mentioned.
They have strike of the Arunachal Pradesh District Based Entrepreneurship Act, my lord. I don't know why they have, I don't know why they strike off that portion.
Anyway, the estimated cost of the tender is 99.3 crores.
Yes, my lord.
So is that within your capacity?
Yes, my
Work.
lord. Yes.
You can handle up to which? what
Yes,
amount?
more than 100 crores, my lord.
More than
I can
100
handle,
crores.
yeah.
Being class one contractor
Yeah, being class 1A contractor
in the state of
Assam.
Arunachal.
in state of Assam.
That is in Assam. What about Arunachal? The work
Arunachal, it is
the work
class
is
one.
pertaining to Arunachal, isn't it?
I am referring to class of Assam, my lord.
No,
And
this contract work is by the state of Arunachal Pradesh,
for
not Assam.
oh, no, this is for APST and non-APST. Even this, the contract whom it is awarded, that is one is from Dibrugarh, my lord. They are also relying on class 1A.
So
Registered contractor
APST
from
and
Assam.
non-APST. correct?
Yes, yes,
You belong to APST,
yes.
but you have a contract registration
Yeah,
as
Assam.
class
Assam.
one
A in Assam.
A in Assam.
Yes,
So on that basis, you can participate
yes, my lord.
for contract works
Yes,
more than 100 crores also.
yes. And these two farms whom has been selected in technical and financial bid, they are also from Assam. Registered in Assam contractor enlistment.
As A1.
Yes, A1. They are equally eligible and I am also equally eligible, my lord.
But the only problem is that you're saying that it was not advertised.
Yes, it should
So
be advertised, my
you
lord.
did not know and
Yes.
you could not participate,
Yes,
and that has infringed your right.
yes, my lord.
Equality clause, Article 14.
Yes, my lord.
Yes, government, Mr. Tapin,
No,
why are you not publishing widely?
Lordship,
What are you hiding?
after Lordship,
Huh?
this e-tender has been introduced, Lordship. So for publications of the tender, Lordship,
Yes,
that has been done through Lordship. That's called Lordship CPP portal, Lordship. That
Mhm.
is Central Procurement Portal. This regulates the entire Lordship, the e-tender all over the India, Lordship. If Lordship enter into this very portal, Lordship, every state has their own portal again, Lordship. And as per the guidelines as given under CPW manual, Lordship, we have to upload, Lordship, the tender in our respective, Lordship, portal. In our state government, we have our own portal that is called arunachaltenders.gov.in, Lordship.
Hmm.
We have uploaded the Lordship, and it's available in the CPP, that's a Central Procurement Portal, Lordship. And that is how, Lordship, the government has formulated this particular, Lordship, mode of publications of the e-tender, Lordship. That has been given in the CPW manual, Lordship. Lordship, present case, Lordship, before coming to the merit, Lordship,
Yes.
see on the same issue, Lordship, this is the third read petition, Lordship. One, Lordship, contractor, Lordship, association, Lordship. Then item number 26 to this item 26, Lordship. And this is the third read petition on the same issue. Only the copy paste, Lordship. Pleadings also almost same, Lordship.
No, what are those writ petitions earlier?
Earlier, the same issue, Lordship, I did item number 26 of to this matter, Lordship.
My lord.
Because in Lordship, the past read petition filed by Lordship, contractor registered, Lordship.
Hmm.
On local, it was dismissed, Lordship.
That was the first,
That was the past, Lordship.
Okay.
Then second, Lordship, item number 2 is item number 26, Lordship. There also we have raised maintainable to the read petition because registration certificate of the petitioner is already lapsed, Lordship. On last occasion, Lordship, it was raised. Now this petitioner has come, Lordship. It's very apparent, Lordship, who is playing behind this read petition, Lordship. If Lordship see the pleadings, Lordship,
item number,
Ditto, Lordship,
item number 26.
26, Lordship. MS Ragaku Enterprises, Lordship. The pleadings also almost copy paste, Lordship.
Why is it this
No,
item,
dear-
item 26 listed today?
Today, Lordship, for disposal, Lordship, record was called, Lordship. We was asked to, Lordship, file affidavit, Lordship, or to bring the record, Lordship, in item number 26, Lordship. But in 26, Lordship, even the extra copy was not served, though in status quo order has been passed by this one, Lordship. We express our urgency for early disposal, because its project is about the upgradations with the hospital losses. It's public interest real losses. So therefore, we express urgency of its early disposal losses. And even after interim has been passed by this, even the extra copy has not been served till today losses. This is item number 23. And this is the third writ petition lawsuit.
My lord, I have
Same
served,
lawsuit, same ground, same issue. And nature of pleadings also is.
no,
ba-
it's,
copy paste
yeah,
lawsuit.
no, that's not my lord.
This is
My
sort
lord-
of a mischievous lawsuit act to satisfy the personal
No,
interest of a
lord.
same one
It's very
person
com-
behind the scene lawsuit. Anyway, apart from that lawsuit, kindly see lawsuit. What is the basis of the pleadings lawsuit? The CPW manual 2014 lawsuit. 14 has been done away. That has been already superseded by 19, then 22. Another two lawsuit updated manual has come up lawsuit. Kindly come to lawsuit. 2014 is the basis of the submission.
No,
Basis of
no,
the
just a minute. Is it 2014 or 2013?
2014 lawsuit. Lawsuit that is 8th page,
Your lordship, I have placed 2019,
page 192.
22
lawsuit.
also, my lord.
Okay, 193 is the 2014.
192 lawsuit,
Hmm. This is 2014.
14 lawsuit.
Hmm.
Then kindly come to page 197 lawsuit.
This is 2019.
That is lawsuit 2000. Sorry, I'm sorry, lawsuit. This is 2003, 203 lawsuit.
Hmm?
203 is the 19 lawsuit.
203.
203 lawsuit. 192 is 2014 lawsuit.
200 203 is 2019.
19 lawsuit. And what is provided in 19 lawsuit? See?
Where is
Kindly. In 19 lawsuit, that relevant has not been annexed lawsuit by petitioner. Then
there is 22 also.
yes, 22 also.
So which is relevant?
22 is the lawsuit, latest one.
So let us go to 22.
Lawsuit,
then.
kindly come to page 108 lawsuit, 208 lawsuit. I'm taking lawsuit to the page 210 lawsuit, 210 lawsuit. Kindly come down to the below lawsuit 4.4.
Hmm.
E-tendering lawsuit. As per rule 159 and 160 of GFR 2017, it is mandatory to e-publish all tender inquiries, request for proposal, request for expressions of interest, notice for pre-qualifications, registrations, or any other notice inviting bids or proposal in any form. Corrigenda thereon and details of bids ever on central public procurement portal, as well as the website of the department, and to receive all bids through the e-procurement portal in respect of all the procurements respectively. However, individual cases where confidentiality is required for reasons of national security, such provision would be exempted. The decisions to examine any case on the said grounds should be approved by the so and so lawsuit.
Hmm.
Then second lawsuit, all the tenders quotations are to be published in CPW, the portal, which is linked to CPP, this Central Procurement Portal. The URL address of the service provider for hosting the e-tender platform for CPW shall be as per instruction from time to time. Presently, the e-tendering platform for CPW has been hosted by the service provider with URL address so and so, tender.so-and-so. The tender will be hosted on so and so as per the instruction time to time. The link of service provider is available on so and so lawsuit. So this is the lawsuit, the latest guidelines lawsuit, and also relevant is at page 216 lawsuit, 216. It substitutes the lawsuit, the earlier lawsuit, publicity of tenders lawsuit. On top lawsuit,
Yes.
4.12. All tenders of any amount shall be invited through e-tendering system. Notices for all the works, irrespective of their value, shall be published on the website .etender.cpw.gov.in as instructed from time to time. Once published on the website, tender notices will also become available on www.so-and-so intro system link. Sample notice for inviting tender so-and-so is available in the SOP and so-and-so. So this is the lawship. It has only substituted the lawship, the earlier provision as provided under CPW.
My Lord, in publicity of tender 4.12, my lord, it is also written that in exceptional cases, if press publicity is required to be given apart from website publicity, written permission shall be obtained from next higher authority. Your lordship, in CPW manual 1922, it is nowhere written that newspaper publication has been done away, my lord. This is the exceptional cases, my lord. This is a global tender as well as open tender. In case of open tender, your lordship, it should be widely published, my lord. My lord, reliance could be made on the notification
No,
dated
it says, the otherwise it says that in exceptional cases, if press publicity is required, then
Yes,
permission has to be taken.
yes.
And if they find that press publication is not required, then why should they take permission?
But your lordship, this is an open tender as well as global
Ah,
tender. That,
Maybe
yeah.
the wording here is that in all tenders of any amount, the same should be invited through e-tendering system. So this is the 2022
22.
prescription. Now, if you want to fall back to the publication, then you have to take permission. So how does it help your case? Now, Mr. Tapin,
Lawship.
what about this notification of 2018 pointed out
Lawship.
239?
Lawship, kindly come to that very notification, Lawship.
Which one?
Page 239, Lawship, to the
Yes.
18 this. Lawship, this is firstly, Lawship, this is general in nature, Lawship.
Hmm.
And so per CPW manual is a special Lawship guidelines, frame for Lawship, tender Lawship. And so per this particular notification is concerned, issued by the government, it's for general publication, advancement for employment and all sort of Lawship publications. But what it guidelines says, Lawship? It's the guidelines. The government of Arunachal Pradesh is pleased to approve the following guidelines to regulate the issue of the release of government advertisement to the print media. Print media, that's a paper publication. It lays down only the guidelines for paper publication. It doesn't say, Lawship, the all advertisement has to be published in the newspaper or in print media, Lawship. That may be noted, Lawship. But apart from that, Lawship, what I'm submitting is, Lawship, so for tender is concerned, CPW manual is the Lawship special guidelines frame for this particular work, Lawship. And this is for general works.
Your
for
lordship,
all age.
the role of Department of IPR is to regulate the publication of NIT of government tender, my lord. Then what is the role of Department of Information Public Relations Office,
Here
my lord?
it says, Lawship, if the government opt for publication through print media, Lawship.
My
The
lord,
moment we enter into
Just a
print,
minute. Don't argue, both of you. Let Mr. Tapin complete.
okay,
You
pardon.
just note down his argument and you come back to the court, okay? If both of you submit together, then court will hear whom?
Oh, bless you.
he'll have his right to rejoinder, Lawship.
Yes, you have a right to reply to him. Just wait for some time. Let him complete. Yes, Mr. Tapin?
Lawship, the moment we enter or decides to, Lawship, go for print media, Lawship, then this very notification comes into play, Lawship. It lays down the guidelines. Once we opt for print publication in print media, then it will regulate us, Lawship. It doesn't say, Lawship, we have to, every government, Lawship, advertisement has to be.
I understand. What you're saying is that normally the CTPWD manual 2022
Lawship.
should be followed by
Followed.
following e-tender.
Lawship.
Now, if an occasion arises that one has to go for paper publication,
No,
then a permission of the authority is required.
required.
Now, once permission is given,
No.
your advertisement will be regulated by this notification of 2018.
Correct.
How you have to publish.
Lordship. This correct. Lordship.
So it is not mandatory.
It's not mandatory. Lordship.
My lord,
Then apart from that, lordship, this may I take lordship to the one GFR lordship.
Where is that?
My friend already took lordship to
221.
GFR is a page lordship.
He was referring to 221.
No.
GFR 2017.
Lordship. GFR is at page 320 lordship.
Sorry,
320.
320.
320.
my lord,
Oh, sorry.
I'm
Not
sorry to
320.
interrupt. My lord, I am sorry to interrupt. When we comes to the GAPR Rule 161, Clause 3, reliance could be made on the newspaper publication of the same department, my lord. In May 2025 also, page number 228, my lord. 228.
Lordship, GFR is at page 2.
No, this is a newspaper publication, my lord.
Lordship.
Published by the executive in the PWD. This is of worth amounting to 98 crores 98 lakhs, my lord. In this notice inviting e-tender was published in Arunachal Times recently. And here it is clearly mentioned that the tender's form and other details can be obtained from the website http://pwd.ar.etenders.in. The press notice is also available in the same website. This is the correct procedure, my lord. In other division, they have followed the correct procedure, but where the said NAT in issue was not follow the due process of law, my lord. Even in page number 229 also, this is the NAT published by executive engineer PWD. This is also, my lord, of 2023 May. In here also it is written that the bid, this is of e-tender, my lord. The bid form and other details can be downloaded from the website http://arunachaltenders.government.in from 12 hours from 21/4/2022 onward. The press notice is also available in the official website www.arunachal.pwd.org. Your lordship, this is the PWD department. They are following in other division. They are following the due process of law by publishing e-tender in newspaper, but where the seat NIT issue was not, my lord. That is the question need to be examined and pondered upon by this honorable court, my lord. There is a malicious intention to keep this NIT from the public domain, my lord. Ill intention is established, my lord. And my lord, in page number 218, my lord, notification issued by the Principal Secretary, Government of Arunachal Pradesh. In this notification, partially the e-newspaper publication was done away. Your lordship, it was partially done away, not completely done away, but same was superseded by the Chief Secretary in notification dated 19 August 2020. Your lordship, in supersession of, may I read the notice, my lord? In supersession of our earlier government order notification such and dated 24 September 2019, mandating procurement of goods, service, government department director, office, societies, board, PSU, through government e-market, except in respect of things done or committed to be done before such suppression, Government of Arunachal Pradesh is pleased to order that in view of publicity of Vocal for Local, Atmanirbhar Bharat, to encourage local entrepreneurship, the first priority on procurement of goods and services shall be done locally through normal tender. And further, that only when items are not able locally through normal tenders, the procurement shall be done through government e-marketing. This notification come into force with immediate effect. By virtue of this notification, mandatory publication as usual, it was restored, my lord. By virtue of GFR issue of 2017, in 2026, Secretary issued it in state like Arunachal Pradesh, state like Northeastern state, just for local for vocal, it is mandatory to publish in newspaper, my lord, to attract the indigenous bidders, my lord. Indigenous, yeah.
What do you say about the CPWD manual to 2022? Is it applicable to the state of Arunachal Pradesh?
Yes, it is applicable. However, my lord, this notification regulate the CPW menu in Arunachal. It is applicable, but however, this notification, the notifications of Chief Secretary, notifications of the Director of Information and Public Relations regulate the NIT, how NIT should be published or to be published, my lord.
Where is the Chief Secretary's notification?
This is in 219 page. Earlier
290.
in 2000, in 218 and 19. Earlier in 2018, the Principal Secretary, Government of Arunachal Pradesh, tried to regulate the GFR, my lord. They have partially done away the mandatory publication newspaper, but seeing the importance, seeing the need in the state, it was superseded in 2020. By virtue of this the notification, any government tender must be published in newspaper, my lord.
It says procurement of goods and services.
Yes, this is what the tender is, my lord. This is also said, and this also
Is it for procurement of goods?
procurement
tender?
of goods and service.
It is for construction of hospital. Can you say that it's a procurement for goods?
My lord, in CPW manual also, it talks about procurement of goods and services, my lord. And this include the construction work also, my lord. We cannot differentiate the procurement goods and service and construction of highway, construction of building, etc., my lord. It is all these things is covered up under this, my lord, this notification and this manual, my lord. My lord, since inception of the Public Work Department and any executing agencies, my lord, since from many decades, Government of Arunachal Pradesh, they have been publishing, though it's e-tender or though it is offline or online tender, they have been publishing.
All right,
through
Mr.
newspaper.
Council, I think I've heard enough of you. Let us hear Mr. Tapin.
Lordship, kindly come to the GFR is at page 221, Lordship.
Mr. Tapin,
Lordship,
one question.
Lordship.
You are saying that the e-tender is the order of the day. We go for e-tendering.
Lordship,
If you put up in the portal, that's sufficient.
Lordship.
Now, if that is the case, why are you still advertising in other cases?
Yes.
Like there are a number of
Yes.
advertisement.
This is recent one, my lord.
Please, Mr. Council, take your seat.
Order.
Take your seat.
Order.
Please sit down. If you interrupt, then we cannot proceed. Mr. Tapin,
Lordship.
so tell us, in some cases, you may want to give the advertisement in the local daily. In some cases, you say portal is enough.
Lordship.
Why is that?
Lordship, it's since it's admitted position, Lordship. Sometimes it seems, Lordship, from this annexures, Lordship, annexure 12 Koli, Lordship. Sometimes it seems the government even goes for, Lordship, publication through the newspaper. But it doesn't mean that e-publication is not there in the portal, Lordship.
No, it is there, no doubt.
It's there, Lordship.
But
But-
the spirit behind
but-
is that white publicity.
But even, yes, that's correct.
You are also accepting by publishing all these NITs, which is from page 267 onwards.
Lordship.
Okay. These
Yes.
are all recent publications. You are, in one way, you're accepting that apart from the e-tendering, newspaper publication is required. Because you're publishing it.
Lordship,
Otherwise, why should you go for this?
Lordship, to my understanding, Lordship,
Hmm?
it is in addition, Lordship. It's in addition to
Ah.
what is required, Lordship.
In addition to what is
What is required, Lordship? What is required is, Lordship, publishing in the e-portal, Lordship.
Hmm.
That's enough, Lordship. In addition to that, if we do that, Lordship, that can be ground for lordship to go with the same mode of publication lordship. To my understanding, lordship. Kindly see lordship whether publication in the portal as per the CPW manual is enough or not lordship. If lordship sees the various judgment of honorable this honorable court as well as honorable Supreme Court, what the honorable Supreme Court says lordship, the publications is through the mode as prescribed in the guidelines by the government. The mode is already prescribed in CPW manual lordship. We have followed it. Lordship. And compliance is complete.
What has happened in
It
the
may
other,
happen, lordship.
Mr. Tapin, what has happened in the other case? Is item 26. This is also on the same tender.
The same.
What is the position? Why is it listed today?
Today, lordship, for disposal, lordship, we have been asked to lordship.
Asked to?
We have been asked to file affidavit or to bring the request lordship.
Okay, regarding what issue? Same thing,
Same, everything same.
publication.
Same, everything same. Lordship. If lordship see the paragraphs also lordship,
No.
copy paste. Lordship.
It's okay, maybe copy paste, but
No.
what, the councils are different in that.
Council-
Party is different,
I appear for the beneficiary in the item 26.
26.
This is the same element.
And that petitioner is the respondent number
Yes, I believe I have also been maybe respond number 4, but I have not found any paragraph nor any.
4 in this case, present case.
Yes,
Oh, I see.
I was only sitting because my learned counsel had referred about 86 at that point. of time.
Give me that item 26, let us see.
But I'll file depending on the outcome of my.
Status quo was directed
Yes, it's
till today.
till today. In all these read petition lawsuit, representation filed by the earlier, the past read petitioner lawsuit, that has been used lawsuit. The representation which is being used here lawsuit, there's the same representation filed by the past read petitioner.
Obviously, the case is that it was not advertised. He also says that not advertised. Now, what does the record say?
Lawsuit, this is, we have published it through lawsuit. Portal lawsuit. We have our own lawsuit. When portal uploaded on that lawsuit.
Publication in the portal is enough.
And upload. And even if lawsuit see the GFR lawsuit, GFR 160, 159, 160, 161 lawsuit, read with the CPW manual 2022 lawsuit. Makes very clear lawsuit. That's enough lawsuit.
Show me that GFR, where?
Page 221 lawsuit.
221.
221 lawsuit. Relevant is at page 222 lawsuit. 222 lawsuit.
Yes.
Page.
Which rule?
Rule 159 lawsuit.
159.
Yeah, 159.
This is ministry, government of India.
Yes, this lawsuit
CPW.
CPW
and also
is of the-
for- This is also central.
central lawsuit. We are following the CPW manual.
CPWD manual of 22 is the center.
Yes,
Then GFR also is the center.
central lawsuit. we are following these two rules also. We don't have our own lordship separate
So rule 159, what does it say?
lordship, married lordship.
Yes.
It is mandatory for all ministry, oblique departments of the central government, their attached and subordinate office and autonomous so and so to publish their tender inquiry, corrigenda thereon, and details of bids on Central Public Procurement Portal, CPP lordship. Individual cases where confidentiality is required for reasons of national security would be exempted from mandatory e-publishing requirement. The decision is to examine any case on the said grounds should be approved by the Secretary of the Ministry oblique Department with the concurrence of the concerned financial advisor. In case of autonomous bodies and statutory bodies, approval of the head of the body with concurrence of the head of the finance should be obtained in such cases. Statistical information can information on the number of cases in which exemption was granted, and this is about the examination lordship. The above instruction apply to the tender inquiries oblique request for proposal, request for expressions of interest, notice for pre-qualification oblique registrations, or any other notice inviting bids or proposal in any form, whether they are advertised, issued to limited other parties or to a single party. In the case of procurement made to so and so, rate so and so, ever need to be published. This instruction would not apply to procurement in terms of so and so. Then kindly come to rule 160 lordship, e-procurement.
Rule
It-
161,
160 lordship.
160. Okay.
160. It is mandatory for ministry department to receive all bids through e-procurement portal in respect of all procurements. Ministry oblique departments which do not have a large volume of procurement or carry out procurements recur only for day-to-day running of offices and also have not initiated e-procurement through any other solution provided so far may use e-procurement solution developed by NIC. Other ministry oblique department may either use e-procurement solution developed by NIC or engage any other service provided following due process. This instruction will not apply to procurement made by ministry oblique department through so and so contract. In individual cases where national security, this is the same thing, lordship. Then kindly come to 161 lordship. Advertised tender inquiry, subject to exceptions incorporated under Rule 154, 155, 162, and 166. Invitation to tenders by advertisements should be used for procurement of goods of estimated value of rupees 25 lakhs and above. Advertisement in such cases should be given on Central Public Procurement Portal, that is CPP, at www.government.in and on so and so. Any organization having its website, own website should also publish all its advanced tender inquiry on the website lordship. The organization should also post the complete bidding document in its website and on CPPs to enable prospective bidders to make use of the procurement by downloading from the website lordship. So these all lordship, it says lordship, it has to be done through lordship. We have to upload it in our own website and in the CPP, that is a Central Procurement Portal lordship, which we have followed lordship.
So is there anything to demonstrate that you have followed that Central Public Procurement Portal,
Lordship,
the records which you are to present today? Is there any indication that
Lordship, that records,
then,
actually I have not yet received lordship. Part of the record has come,
see, it's your own submission that we have to comply by this GFR
lordship,
and also the CPWD manual.
lordship.
There are no such compelling provisions that you have to publish the newspaper.
Lordship.
The decision is yours. If you feel that paper publication is required,
Lordship.
in such cases also you have to take permission. But in the present case, you have followed this GFR, you have followed the CPWD manual,
Lordship.
which is applicable to the state of Arunachal Pradesh.
Lordship.
So whatever you have stated have to be demonstrated by your records, that this is how we intend to procure this is how we intended to call the tender through e-tendering. The record should reveal that.
Yes.
Does it reveal?
No, no,
Which one?
records.
What is that record then?
Record has not yet received lawsuit,
Huh?
not yet received. This is a manual only lawsuit.
No, we asked for the records.
Records,
In that case, item
in item
25,
number 26 lawsuit.
26.
26.
Do you have the records with
For
you?
that lawsuit, can it be taken up tomorrow lawsuit? Because records, as I've submitted.
Definitely we'll take it up tomorrow, but the interim will be there. You will
Yes,
not
sir.
proceed, you will not proceed.
In item number 26, interim is there lawsuit. It will apply
This will apply here also.
till today lawsuit.
Will apply here also.
Lawsuit.
You must demonstrate that you have followed all these procedures.
Lawsuit. Tomorrow lawsuit.
Which will be, of course, in addition to whatever he has to submit regarding newspaper publication is necessary.
Lawsuit.
That fact will also be considered.
Lawsuit.
But first of all, since you have taken the stand, specific stand that we follow the e-procurement method.
Lawsuit.
So we would like to see how we have initiated it. After all, the idea behind
Quite powerful.
is on public interest.
Lawsuit.
And public interest means there should be more participants, more and more people should know. And you have to consider the interest of the region also.
Correct. correct. And apart from this lawsuit, just I would like to raise lawsuit, whether the present petitioner lawsuit, whether he is eligible or not.
No, that you have raised in the other petition also. You are a contractor which is not, you don't have the means to participate in this kind of contract. You have raised. Maybe out here also you may want to say the same thing. But first of all, prima facie, he says that he is a class 1A contractor in the state of Assam, which is equivalent to class 1 AA in the state of Arunachal Pradesh, wherein he can participate for contract works more than 100 crores. There's no limit. That's a different thing. Now, first thing is that they have raised the issue of advertisement. You say that it's not required in papers. We've done it, but through the process as provided by the CPWD manual and the general financial rules, which applies to the state, since we don't have the own separate manual and rules. So you show me from the
Yes,
reports.
tomorrow.
It should be black and white,
Correct, lawsuit.
isn't it?
Lawsuit is correct. Tomorrow. lawsuit.
Otherwise, presumption will be drawn that there's something there.
Correct. lawsuit.
Ah.
Correct.
Tomorrow.
Tomorrow.
Yes, Mr. Counsel, let him come with the records.
Okay.
We have to thrash it out at this stage only because that's important.
Yeah.
Because this matter cannot be lingered
Yeah.
because construction of some hospital is there,
Yes.
money is there,
Yes.
involvement is there. And the purpose of construction is also there.
Yes.
So we have to decide. So instead of issuing notice and getting all that, we'll see the records and we'll see. We'll hear you also, Mr. Counsel. We'll hear you. Let this come together. It'll be better because it's connected. All right, just write like this. List this matter again tomorrow, give the date, along with WPC number 376 of 2023. To stop the learned senior government advocate, Mr. S. Tapin, shall produce the relevant records in original for perusal of this court. Yes, status quo. Respondents are directed to maintain status quo till then.
All right.
Obvious. My lord, I beg pardon for the interruption.
You must listen to the
I-
court also
yes.
sometimes. You only one
I'm
need to listen
sorry.
to you.
Yes, my lord.
You have to listen to the
Yes.
court also.
Yes. I beg pardon.
All right.
I apologize.
All right.
Item 26, I pay for response number 4. Item 26.
Ah.
So taken out.
You want your name to be recorded?
I'm appearing already in that.
It's all right.
That's what I wanted to say.
Yes,
Good.
we'll hear you also.
Good. Number one.
Yes,
My lord, I am agreed by the action of the respondent number 2 and 3 and of reopening a case which was disposed by a court having jurisdiction after a period of 5 years, my lord.
this is listed for admission
Yes, my lord.
today.
Yes, my lord.
Have the pleadings been exchanged?
Yes, my lord.
Who is appearing for the other side?
I am appearing for.
Mr. Kamru, private respondent, Mr. Ratan is for the state. What is the issue here?
The issue here is, my lord,
Can it be disposed today?
yes, my lord. It's a very small matter. my lord.
Small matter.
Yes, ma'am.
Small matter means
Basically, it's a
Basically,
dispute between the private.
Private
respondent and
respondent,
the Petitioner. State has a very small role to play.
normally it starts with that small matter, then you end up hearing the whole day.
no, my lord, it will not take much time. my lord.
All right, what is your case?
My lord, my case is that I am agreed by the action of the respondent, government respondent,
Hmm.
for reopening a case which was disposed by a court having jurisdiction after a period of 5 years, my lord.
Where is that?
My
Court's
lord,
court's decision.
I'll take my lordship straight away to annexure 9, my lord, page number 32, my lord.
Page 34,
32, my lord.
32.
Yes, my lord.
Decision of the court,
Pardon, my lord.
decision of the court,
Yes, this is order of the court, my lord.
dismissed.
Yes, dismissed.
What is this? This, is it a decision? It's a dismissed. That's all. The appellant is absent of despite being summoned twice.
Yes.
So and so is present.
Hmm.
So it is clear that the so and so is not interested.
Yes,
This is a technical dismissal, I think. Dismissal for default.
yes. Thereafter, my lord, no appeal.
What case is this?
Initially, my lord, I have a
What is this case at page 32?
page 32, my lord. Initially, my lord, there was a land dispute between.
No, yes, tell me the title appeal.
Yes,
My lord,
Title appeal. Title appeal number?
it is detailed here, Lordship. 10 of 2014.
10 of 2014.
Yes, my lord.
This is the court of first instance or the appellate court?
This is my lord, appellate court, my lord.
Appellate court.
Yes, my lord.
Now, where is the trial court?
Initially, my lord, I'll, page number 13, my lord.
No, just a minute. You just answer the query. The title appeal 10 of 2014
Yes, my lord.
arises out of which
Out-
case?
out
Which
of-
judgment?
Out of, my lord, Keba decision 23/12/2004.
Where is that?
It is at page number 3, my lord.
Page number?
Page number is 17, my lord, annex 3.
Page 17.
Yes. This is local Keba decision, my lord.
Keba.
Yes. Married, my lord.
What is the reference of this Keba? I mean, how is it registered?
My lord, before this 2004,
Any case number such like that? Or just the date?
no, my lord. The order-
Like for instance, we have the title appeal number 10. Now, in case of the Keba, is there any reference? Is there any registration of number and all that? Year, case number?
My lord, on top, JK, left side, my lord,
Yes, what is this WS, JK, KYG?
KYG 942.
What are these?
These are the number, my lord, issued from Deputy Commissioner, my lord.
Keba decision.
My lord, before this Keba decision also, my lord, there was another Keba decision prior to this, my lord. 2002, my lord. 2002, my lord.
Where is that?
It is at annexure 1, my lord.
Page
Page 13, my lord. 13.
13. So we have to know the whole story, you
Yeah.
see.
My lord, I was having,
Just a minute, just a
okay, my
minute.
lord. Next
13,
one, my lord.
this is a translated copy. What is the date of this Keba decision?
1510, my lord, 1510-2002, my lord.
15/10/2002.
Yes. This was the,
And the dispute is between?
dispute is between me, me and private respondent, my lord. Land dispute, my lord.
In 2002.
Yes, in 2002, my lord.
Anbi, you are only 34 years. You are 34 years today. In
No, my lord.
2002, you
No,
you
it
must
was,
have been a
it was between my father,
child.
it was between my father, my lord.
Father,
Yes.
correct. So
Yes.
it's between the fathers,
Yes, yes.
parents.
Both the private, both
Father of the
petitioner, my lord.
petitioner and father of the private respondent number
Yeah.
4. They had a dispute,
Yes,
land dispute.
land dispute, my lord.
So that was settled
So-
by this Keba decision.
Yeah,
In whose favor?
in my favor, my lord.
Okay.
And this is the Kaba decision. Against this 2002, my two
Ah.
Kaba decision, my lord, the private respondent took the matter before the deputy commissioner, my lord.
When?
2008, annexure 2, my lord, 13 December 2004, my lord.
Deputy Commissioner. But this is also another Keba decision.
Yes, my lord. 2002 Kaba decision,
Hmm.
he was not satisfied with the Kaba decision of 2002, my lord. Then he took the matter to the deputy commissioner, my lord, office of the deputy commissioner.
Okay.
Deputy commissioner again ordered the village authority
Ah.
comprising of the member listed here
Hmm.
in annexure 2, my lord, to settle the matter again, my lord. Accordingly, the next page, my lord, annexure 3, 23/12/2004,
Hmm.
the matter was settled again, my lord.
Yes.
And against this decision also,
Now, what is the decision? In whose favor?
yes, according to,
Again in your favor.
pardon, my lord,
The decision for the second time
second time also it was in my favor. my
in
lord.
your favor.
Yes, ma'am.
Okay, that is what I'm asking. Okay.
23,
But can the Keba decision be again opened like that? What is the law?
yes, my lord, it's,
Now, already there's one Keba decision in 2002.
yes, my lord.
Can it be opened again?
No, it's, actually, it has to be, Kaba decision can be challenged. It is guided by
Challenged
1945 regulation,
Challenged before
deputy commissioner.
Deputy Commissioner.
Yes,
So was it challenged?
he challenged it before the.
Deputy Commissioner.
Yes,
And Deputy Commissioner referred it again to the Keba.
Kaba again.
So it's like a review.
Yes,
For what?
madam. Yes, madam. It's like review. I was respondent that time. I participate, madam, because he was the one who was initiating, madam. Then
And in a Keba decision, who is the adjudicating authority?
adjudicating authority are, madam,
Who are the members?
yeah, Gauraj and all,
GBs and,
GVs and political assistant, PA, madam.
okay.
Then, madam came 23.
And that is under what provision?
It's under the provision of Assam Frontier Regulation,
Assam
Frontier
Frontier
Administration of Justice Regulation, 1945, madam.
Justice Regulation. 1945.
Yes, madam.
And what is the regulation number?
Pardon, madam.
Regulation number?
Regulation 1945, madam.
Hmm? Year is 1945, but which particular regulation number provides?
Regulation 1 of 1945, madam.
Regulation 1.
Of 1945, madam.
One provides for Keba decision.
Yes, madam.
Regulation 1.
No,
Now, what is this case you filed? Is a writ petition
Yes, my lord.
under 226.
Yes, my lord. After that, my lord, thereafter, after Keba decision, after settlement of 23/12/2004,
2004. Then,
they again approached the deputy commissioner again, my lord.
okay, under what provision?
No provision, my lord.
There
Simply
has to be some
they,
provision, otherwise, what is the fun in the decision of Keba? If a person can go again and again.
yes,
again and
exactly, my lord. They were, my lord, they were dragging me to office after office, my lord. Page number 19, my lord.
Page number 9.
No, my lord, I was referring to my repetition, my lord.
Yes, you're referring to page number 9.
19, my lord, of my
19.
repetition, my lord.
Yes, what is there? 19.
Again, they were not satisfied with the Kaba, second Kaba of 23/12/2004, 4, my lord. 19, page number 19. Page number 19, my lord. Protest against Kaba held on 23/12/2004, my lord.
Yes, then what happened?
Then the matter was before the deputy commissioner. The deputy commissioner on 24/11/2006, my lord. Next page, my lord, annexure 421, my lord. My lord, this is order of 24/11/2006, my lord.
Yes,
Heard argument, my lord, second fair, my lord. Heard the argument of board counsel on the status of present case, whether it is to be taken as de novo or refer it back to panchayat, as per 46(3) of Assam Frontier Regulation Act 1945. The learned counsel for the respondent submit that a copy of the petitioner should be furnished to him for so and so. This is not so much important. Next para, my lord. After hearing argument of both the counsel, following order are passed. The case will be tried de novo as per section 46(3) of Assam Frontier Regulation. My lord, the deputy commissioner decided to try the case de novo under section 46(3) of Assam Frontier Regulation, my lord.
yes, please carry on.
Meanwhile, my lord, the power of the deputy commissioner to entertain the appeal was seized after creation of judicial officer instead of Arunachal Pradesh, my lord. First track court, my lord. First track court, my lord. First track court, my lord. And accordingly, the case record, entire case was transferred to the first track court at the Basar, my lord. Page number 25, annexure 5. my lord.
What was the deputy commissioner intending to do to retrial
To try the case
De novo.
de novo, my lord.
by the deputy commissioner
Yes,
or by the Keba?
by
the
the deputy commissioner, my lord.
By the deputy
Yes.
commissioner himself.
Yes.
But
It
in
is-
meanwhile, it was transferred again to the fast track court.
Yes, fast track court,
Fast track court.
fast track court. And fast track court started trying the case, my lord. At page number 5, page number 25, my lord. 28/02/11, my lord.
When was it transferred?
Transferred, my lord, I don't have the exact date of transfer, my lord, but the by this time, my lord, by this time, my parent passed away, my lord.
Okay.
And the fast track court order
Ah.
for
For
filing
of the-
memorandum of appeal, my lord.
Hmm?
For filing memorandum of appeal, my lord.
Where?
By this order, my lord, 28/11 order, my lord. Page number 25, my lord. Type copy, my lord. Second FERA,
Hmm.
file the memorandum of appeal mentioning all facts and document on which, my lord. Then, my lord, this order of first track court, my lord,
Hmm.
was
Then.
this order of first track court was challenged by me before the High Court by CRP number 9 of 2011, my lord, Annexure 6, my lord.
Hmm.
My CRP was dismissed, my lord.
Hmm.
My CRP was dismissed and remand back to the court of first track.
Hmm.
After remanding back the case to the first track court start trying the case, my lord. Annexure 7, my lord. Summons were issued to the private respondent as well as me. Annexure 7, my lord. Summons. Annexure 8 is also the proof of court proceeding, my lord. After the remanding back of the case to the first track court on 21/7/2014, the case was listed before the court, my lord. First track court, my lord. Page number 8, my lord. The appellant means, my lord, the person, private respondent who appealed the decision before the deputy commissioner, under whose initiation the case was, the deputy commissioner decided to try the case de novo, my lord. He was absent, my lord, on 21/7/2014. And then the case was listed again on 15th of September 2014, my lord. 2014 is Annexure 9, my lord. 15/9, my lord. The appellant is absent, despite of being summoned twice, my lord. In the premises aforesaid, the appeal petition is dismissed, my lord. Their appeal was dismissed, my lord. After dismissal of this order, my lord, surprisingly in 2019, my lord. In 2019, my lord, Annexure 10, my lord. Annexure 10 and 11, my lord. I was directed to appear before the office of the Extra Assistant Commissioner Kaing, my lord. Annexure 10, my lord.
Just a minute. Yes.
I was directed to appear before the office of the Extra Assistant Commissioner
Hmm.
for the same land dispute, my lord. Annexure 11, my lord. By Annexure 11, you may I read, my lord.
Hmm.
You are hereby directed to nominate 5 members. Each arbitrator submitted to office on or before 11 November 2019 for hearing of Kabang Lobong area dispute case Kaing. This has a reference of Guwahati High Court Itanagar Permanent Branch White case number CRP 9, 2011, category so and so, my lord. By this order, I was directed to nominate 5 members, each for arbitrator, my lord. And they, by this order, they have said they have been ordered by the order of Guwahati High Court in CRP number 9 of 2011, my lord. My lord, CRP number 2009 is at page number 27, my lord. CRP,
Matter was remanded back to the additional district in session
yes,
fast track court.
yes,
But now notice has come from the deputy commissioner
yes, my lord,
and asking you to nominate
yes,
some members.
yes. The matter has already been, my lord, already been rejected, dismissed, their appeal. And as of now, against this dismissal order, rightly or wrongly, any order, there is no any appeal pending before any court of law, my lord. Therefore, the Kaba decision of earlier, first Kaba decision, 2004 Kaba decision, attained finality, my lord.
What are you challenging here? This page 34.
Yes,
Are you
Yes.
challenging page 34?
yes, ma'am, page
11.
34. My contention is that this appeal has already been rejected in 2014, my lord. It cannot be reopened by order, by this order in 2019 after a period of 5 years of the dismissal of the order, my lord.
Hmm.
Of the appeal, my lord. Dismissal of the appeal, my lord.
So that is your case.
Yes, my lord.
Then what do they say in the
They say,
counter affidavit?
my lord, in government say at para 5 of their reply, they say they have issued this order on the basis of the direction of this honorable court in CRP, my lord.
But CRP orders does not like that.
Yes, CRP was directed to go ahead with the trial.
Hmm.
And accordingly, the first trial court,
Hmm. Which paragraph?
paragraph 5, my lord, of government affidavit, my lord, 2 and 3. Private respondent 2 and 3, my lord, paragraph 5. my lord. That with regard to statement made in para 11 of the writ petition, the answering respondent beg to state that the order wide number so and so issued on 4/11/2019, directing both parties to nominate 5 members, each for arbitration during hearing on 11/11/2019. This order was passed based on the judgment and order of the Guwahati High Court Itanagar bench.
No, just a
Right,
minute,
based
just a
on
minute,
the
just a minute. Let me cut you short. At paragraph number 5, they say that they have filed restoration application. And by restoration, after restoring it, the additional district and session judge has orally passed an order where the matter was remanded back to the DC to proceed under the regulation 1945. Let us see the next one. Where is that? Of the counter affidavit. That's why I told you in the beginning, it was dismissed for default.
Yes.
It is a technical dismissal,
Yes.
not on merit. That is why now they're saying that we have filed restoration. And where is the order of restoration?
No
Yes.
order, no order of restoration, my lord.
Can it be like that, Mr. Oral restoration?
Yes, Lordship, it was.
How can it be oral restoration?
Lordship,
Even in the High Court, when we dismiss for default, do we restore it orally? I restore, go rest, go and go your own ways. We have restored it. Not writing, orally. Is it possible?
It is in fact, Lordship, I should say it is not possible, but
Then-
the instruction I have received from my client is that there was a oral restoration.
No, this is an affidavit filed on oath. And you're saying it's oral restoration order. It's not believable at all. Who has filed this affidavit?
Affidavit, both the, I have also filed Lordship, even the government has filed Lordship. This,
Respondent number 4 has filed.
yes, Lordship.
Yes. 2 and 3 also fine.
It cannot be. Restoration application was filed in the year 2015. You have an misapplication number, what, 3 of 2015?
Yes, Lordship.
But without an order, how do we believe you? Orally restored. If what you say is true, for example, for instance, if what you say is true, then why is it not reflected here in the order, impugn order? You are hereby directed to nominate 5 members, each arbitrators submitted to this office on or before 11 November.
My lord, will come to the government's affidavit, my lord.
This order should say, since the matter is remanded back by the DC, by this fast track court to the DC, to consider the same once again under the regulation 1945, you are supposed to, now you please nominate 5 members. That reference is not there. Government affidavit, where is
My
that?
lord, yes, my lord.
2 and 3.
Yes, my lord.
Yes,
My lord comes to page 4, paragraph 6, my lord.
page 4, paragraph 6.
Yes. Roman 1. How
Yes.
This. In the first instance, a letter dated so and so, dated 3/3/2017 was written to the ESC Kaing from CO Judicial DC Office Pangin, Siang, whereby it clearly mentioned that the Honorable Court of the Additional Sessions Judge Basar has written a case file for hearing and directed ESC Kaing to provide report of the same.
What is this?
Very surprising, my lord. On one hand, there is a judicial decision of dismissal. Another saying that the case file has been written back by the additional session judge, Basar,
To whom? Return to whom?
to the DC office Pangin, my lord.
In the first instance, a letter number so and so
Yes,
was written to the ESC
from CO Judicial.
from CO Judicial. CO means
Circle Officer, Judicial, DC
where it
office.
clearly mentioned that the Honorable Court of Additional Session Judge Basar had returned the case file for hearing and directed ESC to provide report of the same. Where is this letter?
My lord, that letter, I'm unable to find it in my affidavit, my lord.
But you have filed this affidavit on what basis? Now, where is that case record?
Yes, report, my lord, will be
Of that, what do you call it?
ESC Siang District. It should be now the
In
the one
in TA means title appeal.
title appeal.
Now, where can we find this title appeal record?
Title appeal record will be with the ESC Siang District.
ESC Siang District.
ESC.
Why is having the title appeal?
Kaing.
Huh? That is as per your affidavit.
Yes, my lord. Others will have to.
Will be with the ESC.
Maybe
Kaing.
this may not be with the ESC Kaing. Otherwise,
Then Mr. Kamduk, what is happening? You know the procedure, all those procedures are same, whether it's in the High Court or whether in the lower court.
Yes.
Procedure are the same.
Yes.
If the matter was dismissed for default and you have shown one restoration application, but how can you say that oral order was passed? Now, where is the file? Where is the record?
Record, as per the government representative, it says that the relevant file has been transferred back to ESC Kaing. So if it is transferred back to ESC Kaing, then it must be in the custody of ESC Kaing.
Yeah.
Or else, Lordship, the file, the record must be with the custody of this additional district session judge Basar. Lordship, instead of going pardon, Lordship, may I suggest, Lordship, since Lordship, it is not displayed that I have filed restoration petition, and it is in fact back to submit that there are a oral restoration of my appeal. So that cannot sustain lordship. I must have to admit that lordship. So lordship, may I pray that direction to a direction may be issued to take up this restoration petition, which is filed before the additional district session judge Basar for restoration of the appeal, which was dismissed for the court.
No, that is one thing. Another thing is that the ESC is already writing an order. Nominate 5 members.
These,
On what basis?
AP order may be set aside also.
No, on what basis? That means he has received the record from the DC, from the
Yes,
he has received from the fast track court.
Yes, it seems so. As per the
My lord,
first IES.
So we would like to see how the fast track court has transferred it to the DC.
My lord, in fact,
How he has transferred.
why? Because the petitioner has sold his land to some other person, and the private respondent could not occupy, was not allowing them to occupy. Therefore, they made those purchasers, they made a complaint before the ESC kind to settle the dispute. Accordingly, this has been issued without going whether this was really dismissed or not. The appeal filed by the private respondent was dismissed or not. And in the meantime, the honorable court's order has been, this honorable court's order was placed, taking clue from that order, this order might have been passed now.
So, Mr. Counsel, you trash it out before the fast track court. If they have filed restoration application, you file your objection.
My lord, they say they filed the restoration application in 2015. my lord. 2019, this impugn order came. my lord. If they were really interested in the case, they would have run after their restoration application. If the fast track court or if the EAC Kaing were not taking up the restoration application, they would have approached this court for early hearing of the restoration application and so on. In between, with 4 or 5 years, they did nothing. my lord.
That it why there was a delay, Lord, I explained in my restoration petition. Earlier, the cause is
Now-
conducting on my behalf. He was selected in the Arunachal Pradesh Judicial Service. Thereafter, he went for training and he joined later on in the service. So during this period also, I could not connect to my earlier course. That was I was of the impression that the case is going on. Hereafter,
Where is this TA 10 of 2014? Records now. Where will it be? Will it be with the fast track court or with the deputy commissioner? Because Mr. Ratan says that there was subsequent some complaint on which basis this notice was issued. Which means that it is not on the basis of the
Yes, my lord.
on the basis of the matter sent by the fast track court to the DC.
My lord, may I take your my lord, to
My lord will.
page number
kindly
9 of affidavit of two entry, my lord. This is the
type
complaint, my lord.
Type copy at page 11.
Page 11 of the
Affidavit by the respondent number 2 and 3.
respondent number 2 and 3.
Yes, ma'am. This is a complaint
Yes.
regarding land dispute case in between Tamipaleng and Tai River of Kaing. This is filed by 5 persons. They are saying that land was purchased by them
From whom?
from the petitioner.
All right, we'll just come back in 5 minutes. Yep, take a break.
To simplify the matter, not to
Yes.
take long, my lord. My lord, the petitioner won the Kava decision 3 times. Private respondent filed an appeal. It was first before the deputy commissioner, then it was transferred back to the fast track court, my lord. Now that he has an order saying that that appeal was also dismissed. Now that is of 2014.
14.
Appeal was dismissed.
Hmm.
And this present impugn order was passed on the instance of 5 persons who claims that they have purchased land from the petitioner.
Hmm. Hmm.
Saying that the matter has not yet been decided.
No, they purchased land from the petitioner. So what is the problem?
Yes, my lord. So in fact,
Is there a dispute between the petitioner and those 5 persons?
no, my lord.
Then-
Now the private respondent,
Ah.
now he claims that the matter was remanded back orally.
Hmm.
Now, here, my lord, what I believe, what to my understanding is that the EAC might have passed it without knowing the status of the case. That it has, this was already dismissed. The appeal was already dismissed.
Yes, so
So, my lord, prima facie, when there is a case of dismissal by the of the appeal,
Hmm.
then this order could not have been passed by the EAC,
Hmm.
reopening the matter. Now, if the respondent claims that no, I had filed a restoration petition, it is for him to be vigilant of his case, and wherever the record is, he should follow up his case. But
correct.
this, I believe that EAC did not have the power.
Mhm.
So the impugn order, maybe set aside, the respondent may pursue to wherever his case lies, my lord.
Now, the case was already dismissed, their appeal, private respondent appeal, whether it was dismissed on the merit or whether it was dismissed on default merit, but dismissed. And in between 5 years has lapsed. In between these 5 years, he does not did anything. He simply says, I have filed a restoration application. Simply saying restoration.
Just a minute. See, this impugn order has been issued on whose instance?
Instance of 5 persons
Okay. What was their complaint? What is their complaint?
complained that
Sum and substance.
they have purchased it for
Land from the petitioner.
but they are
They're being
not
disturbed by the private respondent.
private respondent. They are not
Okay.
being able to initiate their construction.
All right. So we close the matter. Please write down.
My lord, I agreed to the extent that Lordship, ESC, whatever the ESC or CO has passed the order, Lordship. That is, of course, it seems to be beyond their jurisdiction. But since Lordship, I have filed my restoration petition for restoring the title appeal.
That liberty will be there. It's up to you to pursue that. But saying orally it was restored or orally it was passed, that we cannot accept.
If my lord may make an observation, if Lordship does not make any observation on this restoration application, Lordship, then court might say that you are.
No, the restoration
late now.
application
You
is
cannot
there.
file.
Restoration application is present,
Yes,
but there is no order restoring it,
yes. Lordship.
except your statement saying that it was orally restored. That is not acceptable to this court. It cannot be an oral restoration.
Let the appellate court,
So I'll reject
Here
that
on this
content. I will
restoration-
reject that contention that it was orally rejected, so that cannot be a order in the eye of the law. Otherwise, everything will be oral.
Yes,
What is the point of passing an order today also? I'll pass orally and till you go, you may go, you will go and enjoy your fruits of your think case. I've given you oral permission. Yeah, you are Mr. K. Bogo.
okay, Bhuvan.
Heard Mr. K. Bogo, learned counsel for the petitioner, comma, Mr. D. Kamduk, learned counsel for respondent number 4, and Mr. N. Ratan, learned additional advocate general respondent for respondent numbers 1, 2, and 3. Next param, by filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has challenged the order dated 4/11/2019 within bracket annexure 11 passed by the extra assistant commissioner Siang District, Kaiying, directing the petitioner and the respondent number 5 to nominate 5 members each as arbitrators on or before 11/11/2019 for hearing of Kebang Lobung area land dispute case. Kaiying. Full stop. The learned counsel for the petitioner submits that the land dispute between the petitioner and the respondent number 4 was settled by way of a Keba decision as far back as on 15/10/2002. To stop, the respondent number 4, however, still agreed with the decision, approached the deputy commissioner concerned, who again referred the matter for a fresh Keba decision. To stop. Accordingly, a Keba decision was made on 23/12/2004, which also was in the favor of the petitioner. To stop. However, the respondent number 4, being aggrieved, filed title appeal number 10 of 2014. To stop, the petitioner. No. Full stop. The petitioner cancelled that. While the deputy commissioner was in the process of considering the appeal, comma, in view of the separation, is it? Separation of what? Judiciary? In view of the separation of judiciary from the executive.
Lordship, there is the creation of fast track court, Lordship, before separation.
Oh,
Establishment of first.
which one should we use? Separation or the creation of fast track court?
Establishment of fast track.
First record.
However, in view of the establishment of the fast track court, at Basar,
Yes, madam. Yes.
the deputy commissioner. The case was transferred to the state fast track court. Full stop. Aggrieved. No, full stop. The fast track court then, white order dated 28/2/2011, directed the respondent to submit a memorandum of appeal in support of his contention. Full stop. Against the said order, the petitioner came before this court by filing CRP 9 of 2011. Full stop. CRP 9 of 2011 was disposed of white order dated 16/3/2012 by remanding the matter back to the fast track court for adjudication. Full stop. On remand, the matter was listed on a number of occasions, but the respondent number 4, having failed to appear despite the summons issued to him, the fast track court, white order dated 15/9/2014, dismissed the appeal for non-prosecution. Full stop. According to the petitioner, since the 2 Keba decision was in favor of the petitioner, the extra assistant commissioner, Siang District Kaim, could not have issued the impugn order dated 4/11/2019, asking the petitioner and the respondent number 4 to nominate 5 members each as arbitrators for hearing the dispute between the parties. So, the learned counsel submits that this dispute having already been resolved in favor of the petitioner, the impugn order dated 4/11/2019 cannot be sustained and should be set aside. Next para. Mr. D. Kamduk, learned counsel for the respondent number 4, on the other hand, submits that against the dismissal order dated 15/9/2014 for non-prosecution, the respondent number 4 filed an application for restoration of the appeal, that is misapplication number 3 of 2015, before the fast track court at Basar. And the learned court below, by way of a verbal order, restored the appeal. To stop. Upon such restoration, the matter was referred to the deputy commissioner for consideration. Stop. The submission of the learned counsel to the extent of filing miscellaneous application number 3 of 2015 can be accepted. But the passing of an oral order, and that too by a judicial officer, cannot be accepted. To stop. In other words, restoration of the appeal by a verbal order has no legal sanctity in the eye of the law. To stop. Therefore, it has to be considered and understood that the appeal has not been restored as per the accepted principles and norms recognized by law. Next para. The learned additional AG submits that the impugned order dated 4/11/2019 apparently has been issued by the Extra Assistant Commissioner, Siang District, Kaing, in view of the complaint submitted by 5 individuals who claimed that they had purchased land from the petitioner. To stop. Since the respondent number 4 has objected to their claim over the land in question, the Extra Assistant Commissioner appears to have issued the impugned order dated 4/11/2019. Next para. Be that as it may, the materials on record goes to show that the dispute over the land in question between the petitioner and the respondent number 4 has been settled by 2 KEBA decisions dated 15/10/2022 and 23/12/2004. To stop. Be it stated herein that at the relevant time, it was the respective father of the petitioner and the respondent number 4 who were in the picture. To stop. The said decision has never been set aside in view of the fact that the title appeal number 10 of 2014 was dismissed by the First Track Court within bracket Additional District and Session Judge Basar, close bracket, white order dated 15/9/2014. Stop. Thereafter, the same has not been restored. To stop. As such, the next para, as such, upon due consideration and after hearing the learned counsels for the parties, the impugned order dated 4/11/2019 is found to be not sustainable and the same is set aside. Stop. It is, however, open to the respondent, number 4, to pursue the matter before the appropriate forum as may be permissible in law. Next para, with the above observations and directions, the writ petition stands disposed of. Obliged, ma'am.
Ready? Challenging the impugn order at page 47. Directing not to renew my land passbook.
Land passbook.
Land passbook.
Land passbook.
Land passbook. Well, the case in nutshell is like this.
Land passbook. What is the difference between land passbook and land possession certificate?
The land possession certificate is issued in the rural area,
I see.
the private land. Then in the capital or in the district headquarter, wherever the land has been notified as government land, then they issue the passbook, land allotment certificate. That is in the form of passbook.
Land passbook
Yeah,
to private individuals.
to private individuals, only for 30 years.
So your land passbook has been cancelled,
No, not has been cancelled.
has been cancelled,
No, not has not been cancelled.
or has not been cancelled.
Yes.
Then why are you here?
I'm here for very trivial reasons.
Ah.
Because of colorable exercise of power by this deputy commissioner. The fact, my lord, before burdening my lord with the annexure, my lord, I got the land allotment, my lord, in the year 2020.
No, Mr. Tara, what exactly is the problem? You have not been allowed to renew
Yeah, my lord, there are
your
some
passbook.
renew the passbook, but leading to certain facts, my lord. Just I'll demonstrate without burdening my lord with the annexures. I have been allotted a government quarter at D sector, Naharlagun, my lord.
Ah.
Then nearby there was a empty plot which I came to occupy, my lord, in 21/6/2019, my lord. And thereafter the passbook was allowed, my lord. Then,
For that plot,
yeah, for that plot,
passbook.
Then, my lord, what had happened? There is a private respondent who lodged an FIR before the police station on 3/9/2022, and they complained to the deputy commissioner, my lord. Then saying that I have encroached upon the government land, my lord, in the form of
Which private respondent? 4 and 5,
4 and 5.
both of them.
Both of them. Then, my lord, what had happened, the interesting is, on receipt of that, my lord, on 16/9/2022, the larger deputy commissioner forwards the case to the Naharlagun state officer, that is extra assistant commissioner, my lord. Then there was a verification and proper hearing was done. The extra assistant commissioner says, no, there is no encroachment of the government land and no construction activities has taken place in the sector area adjacent to the government quarter, my lord. So then what had happened was, against that particular order, the private respondent again files 2 complaints before the deputy commissioner. My lord will see the,
First, it wasn't a fire.
yeah, that because that is, nothing had happened with that. Because that will be under the Unauthorized Occupation Act, 2003 Act. There is a
No,
special-
how many times was the complaint submitted to the DC?
And DC first, my lord, first was on 9/9/2022. First, then it was forwarded on 16/9/2022 to EAC Naharlagun.
EAC.
Yes. Then the state officer issued notice on 3/10/2022, and the hearing concluded on 14/10/2022. My lord, kindly come to page 31 straight.
Okay, so after verification, they found that you are not encroached.
Nothing, my lord.
But still again, they have complained once again to the DC.
Once against to the DC. Means-
Second time.
Yes, no, second time. no. So now once the deputy commissioner has taken cognizance of the complaint dated 9/9/2022, endorsed it to deputy commissioner. under the Unauthorized Public Premises Act, my lord. The section 4 and 5 was completely exhausted before the extra assistant commissioner. There, the extra assistant commissioner, being an state officer of Naharlagan, says, no, there is no encroachment, nothing. So I do not have the power to cancel the land allotment or the passbook. So then, my lord, what had happened was, then on, my lord, 10/10/2022, the SK means that Super Kanungo was directed to carry out a field report, my lord. He also submitted the field report, my lord. So then, thereafter, this order was passed, and the private respondent again filed complaint to the DC on 10/11/2022, my lord. That, my lord, will find at page 40 to 42, my lord. Then the deputy commissioner again takes cognizance and directs that a 5-member committee was constituted, my lord, by order dated 25/11/2022. And that report, my lord, will find at page 43 onwards, my lord, for a moment, my lord, that I come straight to the impugn order.
Page 40 is the second complaint.
Yes.
Where is the first complaint?
First complaint is at my lord, page 27.
28? or
28.
28.
28.
What is the date? 9 September.
9 September. Then, my lord, next page, my lord, will see page 29. It was endorsed to the EAC Naharlagan. Because the deputy commissioner, being an appellate body, cannot take cognizance of the matter other than endorsing it under section 4 and 5. Then, my lord, kindly see page 30 is the hearing notice. That is 3rd October 2022. Then second hearing was conducted. Page 31. This is 14th October, my lord. Then I files a written statement before the state officer. This, my lord, may skip this, reading this. Now, my lord will kindly come at page 37. My lord, type copy is at page 38.
That is the report.
Yes.
Yes.
Well, let's see, as directed, I have physically verified the government quarter number 24/T type 4 at D sector Naharlagan, which is allotted to so-and-so, administrative officer, so-and-so. On the spot verification, it was observed that quarter allotee for extended brickwork room and quarter premises is lying vacant. No any structures within the quarter premises. So there is nothing I have not done. And then, my lord, kindly come to page 39. This is the order passed by the state officer, EAC come state officer, my lord. Order dated 2/11/2022. My lord will kindly come to the second last paragraph straight.
Yes.
Peruse land allotment documents in connection to the present vacant plot of land in question, and after heard in land to the parties and perusal of the case records, the respondent is possessing same plot of land on the strand of land allotment, right number dated so-and-so, and hence this office does not have jurisdiction to cancel the land allotment as per the above observation. The present complaint case is hereby disposed of. Now, my lord, against the big drop of this, my lord, the normal recourse, my lord, kindly have this Unauthorized Public Premises Act, volume 7. It may volume 8. Volume 8. Purna wala? Ye Purna wala. Naya wala wala. Same. Now, my lord, kindly come to next page. I'll relay the act at later point, my lord. Next page, my lord. Then the complaint, my lord. Then next page, page 40, is the, again, the fresh complaint was filed. That is 10/11/2022, my lord. Now, my lord, kindly see page 41, that is a series, my lord. The 7th November, but my lord, officially it was filed on 14/11. The receipt says with a seal at the left bottom, my lord.
Where,
Page
which
40.
one? Page
41.
41.
This is the, after passing of the order by the EAC, then this second complaint. Officially, it was received on 14/11. Now, my lord, kindly come to page 43.
This is the second complaint.
Second complaint. Instead of filing appeal, my lord, against the order of the EAC, who is a state officer of Naharlagun, my lord. Now, my lord, this is Stirling documents, my lord. In the Stirling document, my lord, this verification report, page 43. That is what, my lord, kindly see, after receiving this letter, this deputy commissioner, my lord, he passes this order, whereas a complaint has been submitted by so-and-so for enforcement of encroachment of land of government quarter number 24, type 4A, D section Naharlagun. And whereas the complainant has also submitted a representation for cancellation of the impugn order dated 3/11/2022 passed by EAC Naharlagun in the above said matter. Therefore, a committee comprising of following officers is hereby constituted to verify the status of encroachment made by so-and-so with compound of government quarter number, but EAC, DLRSO, you know, this was that. So
The order is not 311, it's 211,
yes,
isn't it?
yes,
It says 311 here.
it's wrongly recorded. Now, my lord, kindly come. Next page, page 44. This committee has again given me the clean sheet. At page 44, that dated 28 November, my lord. Page 45 is the verification report by the committee.
44.
44 is the report forwarding letter. And 45 is the report, my lord.
What is the date? 25.
35/11. One paragraph, my lord. I may be allowed to read.
Yes.
The common quarter number 24, so and D sector Naharlagun is in peaceful occupation of so and so. During our visit, he was not in the station. However, the committee observed that there was no dismantle of the government quarter in question. The allotment area of 100 square meter was measured. And also it is found that no construction works have been carried out in the allotted area and within the government quarter premises. The photo of the area is enclosed for. Will you kindly see? These are the officials who have gone and verified. Now, this deputy commissioner.
What is this photograph? Taken by drone, from drone?
Board, yeah.
Huh?
Yes,
but it's all black.
I am also not having the clear one.
So the committee says that there is no encroachment, no construction.
Yes. Now, my lord, for a moment before I'm coming to the impugn order, my lord. Prima facie, my lord.
Which is the impugn order?
At page 47. Before that, my lord, I am pausing for a moment.
Yes.
Prima facie, my lord.
Yes.
This deputy commissioner is not trusting his subordinate. When two reports have given a clean sheet to me, it appears to it appears to me that is having a nexus with the complainant by the deputy commissioner. This appears to be a colorable exercise of power. You cannot harass a citizen in this manner. An administrator is supposed to do the welfare and look after the welfare of the government. Instead of that, you are harassing in colorable exercise of your power. Well, kindly come to this, now this kindly see me. Page 47. Well, I'll only read this two paragraph. One, two, third paragraph onwards I read. In view of the above, The matter is adjourned for today and fixed for next hearing on 13/12/2022 at 1100 hours. The respondent Taking Talom is hereby directed to present before the court on the next date along with written statement and supporting documents related with the matter. Till the disposal, this is important one, till the disposal of the case, the land allotment of respondent Taking Talom shall not be renewed. Can such kind of order be sustainable, my lord? Respectfully not, my lord. This is prima facie nothing but a colorable exercise of the power. And these kind of colorable exercise of power by the administrative officer should not be allowed.
Where is the land allotment?
Land allotment, my lord, I will show this. My lord, kindly come to page 21 and 26, 21 to 26.
Twenty-one.
Page 18, my lord. Sorry. Page
Page-
18. And it's
Page
a one series, yes. Land allotment is given to me on 21/6/2019. Wide memo number DC/LM-07/2019, my lord. Now the map is clear one is here, my lord. This page 20 is the map. Now, my lord, will come to page 21 for the passbook. Once that allotment order is given, then it is converted into passbook, my lord, in the form of passbook at page 21. My passbook number is LG NLG Naharlagan, my lord. That's 15/25/2019.
Now this land allotment,
My lord will come at page 26 for a moment before I answer.
it has to be renewed from time to time?
Yes, my lord, every year. You
What
have-
period? Every year?
Every year you have to pay the
Okay.
premium, my lord,
Now, for what purpose is this land allotment given to you?
for residential, my lord,
Sorry,
for residential purpose.
for residential?
Yes, my lord
This,
will
this land is adjacent to the quarter.
adjacent to the court.
According to you, it's not a government land.
Well, the government has allotted me, my lord. It
No,
is a government land.
It's a
It is a
government land.
government land, government has allotted to me by following due
Okay.
process of law, my lord. My lord, kindly see this page 26. My last renewal was 31/12/2021.
Page 20,
26.
26. Last renewal,
Last is at right, my lord, bottom, 31/12/2021. And because of this impugn order, my lord, I am unable to renew it. Now, my lord, why that's why, my lord, we are challenging the entire process. My lord, kindly have the law now, the act. My lord, I have the page 160 in my book,
page?
160.
Yes, 160.
Yes, the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act, 2003. My lord. My lord, interestingly, act has been enacted, my lord. No rule has been framed so far, my lord. I don't understand, my lord. In Arunachal, my lord, I have done certain research on the local laws. Many laws have been enacted, but no rules have been framed.
Maybe because the act is good enough.
My lord, when there is an interpretation of the act,
No, if the act is not conclusive enough to carry out the provisions provided in the act,
correct?
rules are framed.
Yeah, if it is not workable,
Yes.
and then only that, for the literal interpretations, under sub-delegations only it does delegated legislation. Anyway, my lord, this is the act, my lord. Now, under this act, my lord, kindly come, section 4 straight, my lord, my lord has already dealt with.
Yes, section 4.
Now, my lord, what has happened, the state officer, Naharlagur state officer, has rightly used the provision of section 4 by issuing summon to us. And thereafter, my lord, he has concluded his proceeding under section 5. Then 6 and 7 is for eviction, my lord, that I am not concerned at the moment. Now, my lord, kindly come to section 12. Section 11 is important, my lord, power of the state officer. And the state officer shall, for the purpose of holding an inquiry under this act, have the same power as vested in a civil court under the Code of Civil Procedure 1908 when trying a suit in respect of the following matters. Well, these are summoning, enforcing. This, the order passed by the EAC is in accordance with the section 11, my lord. So there is no quarrel, no dispute, my lord, even no ambiguity on this. Now what happens is, the private respondent, my lord, as I have pointed out, they have filed complaint on 10/11/2022 and 14/11/2022, my lord. Against these, my lord, he ought to have filed appeal against this order, my lord, under section 12, which they have not done. And sarcastically, my lord, the deputy commissioner, instead of resorting to the section 12 of this act, has gone beyond his jurisdiction, constituting a verification committee again and passing this impugn order, from where he has drawn the power unless there is no appeal against the order of the EAC. This is deprecable, my lord. Therefore, my lord, I am challenging the entire proceeding. It is vitiated by mala fide with colorable exercise of the power by the deputy commissioner. I have the land allotment, and you do not have the power under section 12 to stop renewal of my land, my lord, land passbook. If that is to be done so, the deputy commissioner at the most, my lord, could have resorted to the 2000 Land Settlement and Record Acts and rules framed thereunder, my lord, sending it to the higher authority.
Who can cancel the land allotment?
It is by the government, my lord.
Government.
Deputy commissioner do not have the power.
Allotment was given by the government.
Yes, on the approval of the government, my lord, deputy commissioner.
Let us see, where's the
Land. Your lord. Oh, my lord, I have not brought the under one section, rule 125 of 2000, right? 2012.
18. No, the order itself does not state that.
No, my lord, that I have the act, but I forgot to bring the rules, my lord. There is a procedure to process the allotment. It goes to the government, government approves.
Oh, that's okay. See, I'm just looking at the land allotment. It says as approved by the government of Arunachal Pradesh, right, order so and so, is hereby allotted plot of land. So the government has allotted plot of land.
Correct, my lord.
And that has been communicated to you by the deputy commissioner.
My lord, it is
And
like
the
this.
order has been signed by the deputy commissioner.
Deputy commissioner, yes, my lord.
But this is as per the approval of the government.
Approval of the government.
Now, if the question arises that it should be cancelled, it should be by the government.
It is by the government on his recommendations, but he cannot pass this blanket ban order, my lord. Not
Instead of making a recommendation for cancellation, he himself has
assume the jurisdiction of the government.
decided to examine the matter and call for the appoint some committee
Correct.
to look into it, and while summoning you say that no renewal.
He's a delegate, my lord. He cannot override the power of the government.
See, the appeal provision is there, isn't it? Appeal is to be before the DC,
Yes.
isn't it? As per section
12.
section 12, subsection 1.
No appeal. has
And
been-
how has he to deal the appeal?
Appeal, my lord, it should be against the, sorry, my lord.
What do you call this? Silver worm. Yesterday, there was a lizard in my file.
Oh.
Yeah, sitting here. So I was playing around with that lizard.
Leader
Today-
gives you the strength. my lord.
Today, there's a silver worm. Okay, now what does it say here? Appeal so and so shall be preferred. 30 days. How has he to?
That civil court procedure has to be followed for adducing the evidences, cross examinations.
Or execution, and no injunction shall be granted by any court or other than authority respective of action taken by the power of. If any person lawfully occupies. No, what can the deputy commissioner do in the appeal?
The deputy commissioner, my lord, he do not have the power.
You're saying that he has exceeded his power.
He has
He does not have
exceeded-
power to say that you will not accept your renewal or will not allow you to renewal.
We will not renew your.
But what can he do? What can he do otherwise?
He can administratively, because under this proceedings, he do not have the power, one. Administratively, my lord, simply he can recommend it to the government for a decision, look. But here he cannot do, my lord, he could not do, because two verification reports are in my favor, constituted by him only. So therefore, my lord, the whole proceeding is vitiated by colorable exercise of the power.
When an appeal is preferred from an order of the estate officer, the appellate officer may stay the enforcement of that order
Correct, my lord.
for such period and such conditions as he deems fit.
The objective of the section 12 itself speaks, unless a appeal is not filed, he cannot take cognizance. Therefore, this order is bad in law.
No, that is one thing, but another thing is that can it not be treated as an appeal?
He can't, because this order of the EAC was not challenged. EAC, the finding of the EAC says that he do not have the jurisdiction to cancel the land allotment.
None mentioning of the provision of that law, saying that this is an appeal under section so and so, may not
Yes, my lord, there is
may not affect.
19.
If the DC has the power, he has the power, but that power he has to exercise accordingly
Accordingly,
as per
Section 12.
conferred to him,
yes.
isn't it?
No, but again, the question is, he does not have the so moto power. The section 12 does not empowers him. Well, that the question that has fallen from my lord, this 1952 one judgment is there, state of measure versus one gentleman. My lord. There it says, and then subsequently in the latter decision at 1971, my lord, which says the filing of an application under the wrong provision shall not be entitled for
Correct, correct.
dismissal. Lord. I forgot these judgments I have written in my
Okay.
book. my lord.
Anyway, we'll come back at 2.
Yes, my lord.
Mr. Kamduk and Ms. Basard, I think they are feeling hungry.
Yes, because
But-
their affidavits are so vague, my lord. Could not sustain against me, my lord. Grateful. So, my lord, I was making a submission that the impugn order is perverse, actuated with colorable exercise of power, and the deputy commissioner does not have the power under section 12 of the Public Premises Eviction of Unauthorized Act 2003. And there being without any appeal file, he cannot assume the jurisdiction to pass this order, my lord. So therefore, my lord, this impugn order must go along with the entire proceedings.
Yes.
Lordship, the private respondent, though under section 12, he has not filed appeal, your lordship. But your lordship may kindly see the annexure 7, the application by the private respondent, page 41. It is the representation for cancellation of impugn executive magistrate EAC Naharlagan order. They have challenged the order of the EAC, your lordship.
Next, just
741, your lordship.
page.
41. Read petition, your lordship. DC has considered this representation as an appeal, your lordship. And DC is the appellate authority, your lordship. The prayer is for cancellation of executive order, EAC's order, your lordship. And your lordship, there's a serious allegation against the petitioner by the private respondent, your lordship, that not only the petitioner has occupied the premises of the government quarter, but by manipulation, he has obtained the land allotment certificate, your lordship. That is the allegation, your lordship. And initially, your lordship, DC has not, when the complaint was filed before the DC, your lordship, he has forwarded the matter to the EAC. And accordingly, EAC, after verification and examination, your lordship, he has passed this order dated 2/11/2022, your lordship. And against this order, your lordship, the private respondent has filed this representation before the DC, because he is the appellate authority, your lordship. And on 18 November 2022, your lordship, DC has passed the order for constitution of committee,
This,
page 43.
this EAC's order is
Yes.
dated
Dated 2/11,
2022.
yes, your lordship. It's at page,
So the presentation has been
39.
filed without waste of time.
yes, your lordship. Order was passed on 3rd November and representation was on 7th November.
First of all, the complaint was submitted to the DC
DC, your lordship.
and then he
He has forwarded it to
to the
EAC.
EAC.
Yes, your lordship.
Then the EAC conducted the hearing on 2 occasions.
Yes.
And passed which order? Verification report.
Verification, yes, your lordship. Verification is, type copy is at 38,
No,
your lordship.
what was the manner in which it was endorsed to the EAC? You directed to examine the matter and take
Yes.
necessary action.
Yes, yes, page 29, your lordship.
So not only examine and take necessary action. Isn't it?
Directed to examine the
Does
matter
not
and
say
take
that-
necessary action, your lordship.
It
So
does
he
not
has
say,
verified, yes,
that-
there
it
is,
does not say that you submit a report. So what has the EAC done?
your lordship, after, your lordship may kindly see the order.
This verification report is by the EAC only.
EAC has directed to verify.
Oh,
So
Huh?
SK LM department, your lordship, he has verified,
who has verified?
SK lordship. It's LM from the LM department, page 38, your lordship.
What is SK?
SK is supervisor Kanongo. He verifies the, your lordship,
Supervisor
Konongo,
Korongo.
Kanongo.
Supervisor Kanungo, my lord,
Yes,
who carries out the field survey. That geo mapping and all.
supervisor.
Uh-huh. Field supervisor.
Field
Yes.
supervisor kind of, well, it's a typical Hindi name, like our, this IPC is being changed as Nagarik Suraksha. It's very difficult for us to remember.
EAC has in turn detailed the supervisor
Yes, your
to
lordship.
go and verify.
Yes.
So that's why the verification report.
Yes, and on verification, it was observed that quarter allotee for extended brick wall room and quarter premises is lying vacant and no any structure within the quarter premises.
So what
Is
does it
in-
mean?
In his favor only, your lordship. But your lordship, and accordingly, your lordship, in the order, it has said that and hence this office doesn't have jurisdiction to cancel land allotment. EAC doesn't have the jurisdiction to cancel. Land allotment is proper, your lordship, as per this order, your lordship.
No, let us try to understand this order.
Yes, your lordship.
Nobody's talking about who, I mean. Is there any occasion for cancellation? Why does he, why
Because
does he,
the
why
private
does,
respondents is praying for cancellation of land allotment. Your
no,
Lordship.
that's why,
One of the
why,
prayer, your lordship.
okay,
Not only that he is alleging that he has encroached the premises of the government quarter, but he is praying for cancellation of land allotment. So that power is not there for this executive ESC, your lordship, asset officer. So he has forwarded this order to the deputy commissioner, your lordship. He has disposed of this matter, your lordship, by this order, and copy was forwarded to the DC. And since DC is the appellate authority, private respondent has submitted representation before the DC, your lordship. And accordingly, DC has initiated, since he is the authority, your lordship, to pass the land allotment certificate as well as to cancel it, your lordship.
the report it says on spot verification observed that the quarter allotted for extended brick wall room and quarter premises is lying vacant. This extension, there was an extension of the room.
It seems that there is an extension, your lordship, in the government quarter where the petitioner is residing.
For extended brick wall room and
Yes,
quarter
your lordship.
premises lying vacant.
But the premises is vacant as per the verification.
Which
Compound
premises?
of the quarter, your lordship,
Allotted area.
allotted area.
Allotted area is vacant. and-
Allotted area is vacant,
My lord, I know,
but there's some extension of the room.
no, my lord, that extension was done by then joint registrar, who is OSD protocol in Guwahati.
Uh-huh.
That is old extension, which
Extension means extension of the government quarter,
room, yes, my lord, within the
extension of the room,
rooms,
which is a government quarter.
which is the government quarter, and
Okay.
there is no quarrel on that.
That is one thing.
There is-
And the other thing is regarding the lot of land,
In the
Land.
plotted 100 square meter land, my lord, no
lot of land
constructions,
allotted.
nothing.
So what he means to say is that room extension is there. As far as the plot of land is concerned, there's nothing there.
Nothing.
Okay. So in the order itself, I was just trying to understand
Lordship.
at page 39. Order of the ESC, second paragraph. Accordingly, the physical verification report has submitted dated so and so. That it was found that the said quarter premises is lying vacant. no any structure existed near government quarter. Except extended one room with brick wall, this much.
Nothing, no adverse. Meaning thereby, my lord, this Public Premises Act proceeding is not sustainable. This act will come when some citizen illegally occupies and encroaches the public premises. This is not a case of public premises, my lord. Rule 125.
Since the respondent illegally encroached the quarter premises which were allotted to him.
There is a separate law to challenge not like this.
Pedro's land document in connection with so and so. After hearing land, the respondent is in possession of same plot of land on the strength of land allotment order number so and so, and hence this all does not have jurisdiction to cancel this so and so.
They affirmed my land allotment, my lord. That's 5-member committee. The affirmation is not to that extent, the extent of saying that I have not encroached upon.
Despite this, one more complaint.
Yes.
This order of the ESC is not against the petitioner actually, your lordship, but the private respondent agreed by this order, your lordship has filed.
Now,
appeal.
how is the private respondent affected otherwise?
He is not affected otherwise, your lordship. He has seen that some government premises has been occupied by the petitioner, so he has filed the complaint before the DC. Otherwise, he is an unemployed youth, your lordship, as per his representation, your lordship.
Is he also residing nearby somewhere?
No, his area is.
Address, I'll show you, my lord. Is Gopur
Gopur Valley.
is Itanagar, my lord. 16 kilometers away from me. How he is affected, I don't know.
Then how has he filed the complaint?
That's why, my lord, I made a submission that there is a clear-cut connivance between the complainant and the deputy commissioner in initiating this process. Unfortunately.
We have denied that.
No.
Any kind of.
No, of
In our
course, you see, any public spirited person
Yes,
can take the initiative.
Yes,
But normally people don't interfere in other things,
yes.
isn't it?
Usually they don't do, but
Unless there's some catch somewhere.
yes. lordship.
So that's why I'm questioning, that question arises. What benefit does he get out of this? And how is he affected? Understandable if they are two neighbors and they are both are occupying some quarters,
Lordship.
and the neighbor has become so friendly that he started making the adjacent land as his own and somehow fraudulently obtain a pass. That's one thing. But here is a case, a person who is not from the same
directly affected.
from the same area
Yes.
comes and files a complaint consistently. First, second,
FIR also
then
he
the
has
appeal
filed.
or
Yes.
the representation to the DC. Now, on the basis of the first complaint, this order was passed.
Yeah,
Correct.
yes.
Then the second complaint, what happened?
Second complaint, your lordship, of 7th November, your lordship.
Then the
DC
chairman and
has
member.
constituted a committee, page 43, your lordship.
And who are these? ESC only.
ESC.
Is it the
and
same ESC?
TLISO.
No, my lord.
Is it the same ESC or someone else?
No, Itanagar.
Huh?
Itanagar.
Itanagar.
Itanagar, then DLRSO.
The earlier one was what? Capital.
Yes. Earlier one was the supervisor Kanungo, that is a lower rank officer.
No. The
Committee member.
ESC who passed the order.
Yeah,
Oh,
Naharlagan.
yes,
my lord.
Naharlagan.
He is a state
Oh,
officer.
Naharlagan.
Yes.
ESC come
The
state officer.
quarter is where? In Naharlagan.
Naharlagan,
Naharlagan,
this sector. my lord.
Okay,
Well, it's just opposite side of the judges Bangalore.
I see. Naharlagan. ESC, okay. Naharlagan. Now, the new composition is ESC,
DLRSO and official of housing department.
ESC, this is from Itanagar.
Itanagar and District Land Revenue Settlement Officer of ICR region, my lord.
Of?
Itanagar Capital Region, my lord.
Okay.
In Papumpara, my lord, there are two deputy commissioners.
Hmm,
One is for the Itanagar Capital Region
hmm.
and one is for the rural. And where we are sitting, my lord, it comes under the rural.
Rural.
Papumpara, yes, my lord.
So after that, again, your
So
lordship.
this
then
composition is
verified-
from Itanagar, all of them.
Itanagar, your lordship.
Okay. Then what happened
I
thereafter?
have submitted the committee report on
Mhm.
28 November 2022 and report is at 45, your lordship, page 45.
45.
Yes, your lordship.
Is in peaceful occupation. During our visit, not station, then observed there was no dismantle of government quarters. Allotment area was measured and it was found that no construction was having carried out in the government quarters. The photo of the area is concerned. Okay. So allotment is by the government, isn't it?
Yes, by the government.
Let's go back to the allotment again. Come to page 18.
Yes.
So how does this act come into play? This is, what is this act?
Public premises. Eviction of unauthorized occupant Act 2003. my lord.
Eviction of unauthorized occupants. Can you say unauthorized? While you're giving this sort of land allotment order. Supposing there is no allotment order,
Yes.
simply is occupy. He is having a quarter there, extended the quarter, then is also occupying that other area, may construction or no construction. Then the question of unauthorized occupancy of the land may come in, attracting this 2003 Act. Now, if somebody is already given a allotment order,
But the
which
order,
which may be temporary in nature,
yes, your lordship.
renewable every annually.
With a life expander, my lord, 30 years.
So
Up to 30 years.
the endeavor should be to cancel the allotment.
This is the prayer of the petitioner and that is why, your lordship, someone was issued to the private petitioner, your lordship, to appear before the DC after this verification has been done, your lordship.
No, I understand that.
This before passing this impugn order, your lordship, my affidavit, your lordship, page 9, your lordship, we have given the summon to the petitioner to appear before the DC at for hearing of the case with all relevant documents or things to testify material facts relating with the case.
Let us see the complaint now.
Com-
Just let us for a moment, let us just see the complaint. What sort of complaint is it? The first one.
Basics.
It started with FIR,
Yes, your lordship. He has filed an FIR,
land grabbing racket.
private respondent.
What happened to the FIR?
If I may not, the police has not taken cognizance.
Okay.
After seeing the land allotment, my lord,
Hmm.
no case has been made out against me.
Or manage the authority to take, so. Then the first complaint is 28. Is it?
9 September, page 28, yes,
Page 28.
yes.
What is his grievance?
This complaint against government quarter land grabber, Mr. Takin Talom, that is the petitioner, an employee of Guwahati High Court, Itanagar Permanent Bench, Guwahati, of his quarter number, such and such time, D sector, Naharlagan. And the allegation is also that he has managed backdoor policy to get the land allotment done, your lordship. This is also the allegation of
So is the deputy commissioner the competent authority
to issue the land allotment and also, your
to
lordship.
to issue
yes,
the land allotment?
Yes, and to
But-
cancel,
Or not on his own, isn't it?
on approval of the
Approval,
government.
yes, your lordship.
Approval is
should be
required.
taken, yes, your lordship.
So
After
now-
getting the approval, your lordship,
Ah,
he issued
He
the,
got the approval
yes,
and he allotted the land.
yes, lordship.
Now, can he cancel now the land allotment
Yes, he can cancel your.
on his own?
lordship. Not on his own, your lordship,
Ah,
but he.
so what he has got to do?
My lord, I assist, kindly have this volume 7.
Hmm?
Volume 7 of AP code.
What is that?
That is relating to the 2000 Act Land Settlement Record Act. Section 79 onwards, my lord, till 83, my lord. How the land allotment can be cancelled or the LPC, my lord.
Page,
Page 224. My lord, only aggrieved person can avail these provisions, right from section 79 to
224, what is this act called?
this is Arunachal Pradesh Land Record and Settlement Act,
Land Settlement and Records Act 2000.
2000.
And which is the relevant section?
Relevant section is 79 to 83 below.
Section? Section 79.
79 appeals and revisions is such chapters.
Where's that section? Page?
Page 244 below. 244.
Appeals and revision.
Yes, and kindly come to appeal, how it can be.
Hmm? But these are appeals. Where does it speak about the cancellation?
This is how, my lord, if a person is aggrieved by my allotment or the LPC, has to file appeal under this. This is a different.
No, first
Dealing-
of all, you tell me, under what provision
Correct.
is land allotment order given?
That is rule 125. Amar, kindly provide that.
Section 12 of the.
Section 12 of the act, and they read with rule 125.
So the power is given to the DC, it seems.
Two, kindly come to 2. Close to it.
No, 2 is there. 2 is for industry. Public utility. DC can give it for the agriculture purpose and for construction of dwelling house.
Yes.
So DC is the competent authority. If DC is the competent authority, why does it the past say that with the approval of the government?
Please, if my lord permit me to make one statement. The genesis of this 2000 Act, my lord. There was a two powerful cabinet minister in 2000. One was land minister, and another was the UC and UD and housing development minister, my lord. Because of their ego clash, this act where I was part of the government at that point of time was brought in. The UD minister says, without my, the land management UD minister says, without my permission, no bird can fly over the territory of Arunachal. The another powerful cabinet minister says, look, without my permission, you cannot fly your birds in my territory. So that is how this act has come into. There are some deficiency. No, that's why the action which the deputy commissioner has initiated should have been on the rationality of this Land Record and Settlement Act. There, my lord, the procedure of land allotment in Arunachal is, my lord, a application will be filed to the deputy commissioner. Along with the proposal, then deputy commissioner deputes DLRSO along with the SK, my lord. They will make the field survey, the notice is issued. Then on their approval, then it sends back to the government for the approval, my lord. It is not automatic. There is a system in place.
All right. Let me hear, Ms. Basa.
Yeah, my lord. Yes, I was.
Yes, Ms. Basa.
Lordship, may I kindly see the impugn order, your lordship, page 47.
Yes,
May I read, your lordship?
yes.
The matter is regarding to complaint submitted by Shri Gichik Topar and others against Shri Taking Talom for encroachment of premises of government quarter number 24 type 4 located at D sector Naharlagan and for cancellation of land allotment of the plot of land. Complainant Gichik Topar and Taram Konji present. Respondent Taking Talom is absent. As the respondent is not present before the court, hearing could not be done. In view of the above, the matter is adjourned for today and fixed for next hearing on 13/12/2022 at 11 hours. The respondent Taking Talom is hereby directed to present before the court on the next day, date fixed along with written statement and supporting documents relating with the matter. Till the disposal of the case, the land allotment of respondent Taking Talom shall not be renewed, your lordship. After issuing summon also, your lordship, he has not submitted any application for his absence, your lordship, on that day that he's unable to attend, your lordship. This is one thing, your lordship. And this order, your lordship, before this order has been passed, your lordship, verification has been done by the committee. And verification also, your lordship, is in favor of the petitioner only, your lordship. He just had to come before the authority with all his documents to prove that he has valid land documents, your lordship, land allotment. But instead of appearing, your lordship, he remained absent, your lordship. And on the next date also, he could have appeared before the authority. Instead of doing that, your lordship, he has filed his read petition actually. And there is not a blanket ban on the renewal of the land allotment till the disposal of the case, your lordship. It is written, your lordship. So this is not the cancellation, just for till the case is disposed, your lordship. For that period only, your lordship, renewal of the land allotment has been stayed, your lordship. This is the thing. And against this order only, your lordship, he has come. Instead of doing that, your lordship, he could have gone to the authority, produce his land documents and all, your lordship. Otherwise, your lordship, verification report is also in his favor only, your lordship. If you see the verification report. He remained absent on that day, your lordship. And being the issuing authority and cancelling authority, your lordship, he has proceeded with this proceeding, your lordship, the DC, your lordship.
So again, same old question.
No,
What do you say about this past land allotment? Legal or illegal? Is it in order, the land allotment?
It is not in the order, your lordship, that it is.
How?
Your lordship?
The land allotment,
Yes, your lordship, he has an allotment.
is it in order? Is it a proper allotment?
Yes, lordship, this is a proper allotment.
This is how they allot the land, the
Yes.
government.
Yes, your lordship. Approval has been done by the state government, lordship. And after the approval of
mean,
the government,
the-
lordship,
All the other land allotments are in this kind of format.
yes.
Is it in this format?
Yes, yes,
There's no provision, nothing mentioned there.
yes,
Allotted under so and so, under so and so.
yes.
It's not mentioned. Why is it required to be renewed every year? Otherwise,
They have imposed a seized premium as in the form of tax.
tax,
Yes.
no tax can be given.
Yeah, that's,
If you don't pay, you'll have to pay fine like that.
yeah, there's.
But why renewed? Why you required renewal of this pass?
This
They're
is-
also every year.
Yes, ma'am. This is what I am not understanding. There is a notification in this regard. The standing council land will clarify on this matter.
But now with this land allotment order, do you have the transferable right, heritable and transferable right?
No,
You don't.
is there?
Yes, but after the allotment of the land within 5 years, it cannot be transferred.
Huh?
After?
After?
Sorry, before 5 years, it cannot be transferred to anyone else. But
After 5 years, it can be transferred.
it can be transferred,
There is under what provision? That 2000 Act,
that is given in the rule. Also.
2000 Act and rules.
Rules, it is in the rule, 2012 rules.
First, it's allotted to A.
Yes,
After 5 years, it can be transferred.
yes. It says that the land allotment cannot be transferred before 5 years of allotment. That means also after 5 years, it can be transferred.
Can it be cancelled?
It can be cancelled, but Lordship have the rules, Lordship.
Mr. Kamduk, you are for which party?
For the government, Lordship.
Government.
It's Secretary Land Management.
Okay.
The condition is given in the form itself, page number 57. Form 34.
Hmm.
This is the allotment order, Lordship, the format. It says, Lordship, in signal number 1, the allotment shall be liable to be cancelled if there is only 2 grounds, A and B. A says the allotee committed a breach of any of the conditions mentioned herein after or any of the provisions of the Arunachal Pradesh Land Settlement and Record Rules 2012. At any time, it discovered that the allotee was not eligible for this allotment. In terms of the Arunachal Pradesh Land Settlement and Record Rule 2012, guilty of misrepresentation at the time of allotment. Provided that before such cancellation is ordered, a notice is to be given to allotee to show cause against cancellation within a period of 15 days from the receipt of the notice. So these are the 2 grounds. And Lordship, chapter 10. If any provision given in the chapter 10 is breached by the allotee, then only this can be cancelled. There is a chapter 10 starts from rule
But-
123.
Okay, the pass otherwise, the land allotment order contains lot of terms and conditions. Condition 1 to 9. But your appendix only contains 2 conditions. Look, liable, okay, liable for cancellation, A and B. Now, Mr. Kamduk, the thing is that the petitioner has an allotment given in the year 2019, given by the deputy commissioner as per the approval of the government,
Yes,
isn't it?
yes.
Now, supposing this is to be cancelled, how will it be cancelled? Who can cancel it?
It is the deputy commissioner.
Deputy
But-
commissioner.
Yes, but he has to have the approval of the government.
Government,
Yes.
under what provision?
The person may kindly come to the Land Settlement Act clause. Page number 209, section 12. Subsection 2, it says also, the deputy commissioner,
Which one? This one?
yes, Land Settlement Act,
Yes, subsection, section
section 12 also,
12.
yes. The deputy commissioner may allot land belonging to government for agriculture purposes or for construction of dwelling house in accordance with such rules as may be made in this behalf under this act. And now this subsection 2 says, the government shall have power to allot any such land for the purpose of industry or for any purpose of public utility on such conditions as may be described. So here it refers to government laws. So therefore.
No, that's why I was pointing out. One is the deputy commissioner.
Yes.
He has the power to allot for construction of dwelling houses. Now, is it a case here that the petitioner is trying to make an industry out there?
No.
Then, so how does the government come into picture?
For allotment-
Deputy commissioner can give the permission to construct dwelling house. Then government have the power again
Yes.
to allot land for the purpose of industry or for any purpose of public utility. Public utility. So there lies a distinction. For dwelling house, DC can give, but for industry and for public utility, government has the power. Then where is the provision for cancellation?
Cancellation is not given.
Not given.
Yes, Lordship. Here in the act, Lordship.
So the implied,
But only it says, Lordship, if the allotee breach any condition as prescribed in chapter 10 of the rules, then only it can be cancelled.
So out here, has he broken any condition?
No.
He has given allotted a land. There are two verification already done saying that there's no construction. Land is allotted to him.
In fact, before
So
allotment also-
what action is contemplated by the DC? Ms. Basa says that both the verification is in his favor. He should not fear. He should go there and cooperate. But in the first place, why should he go there when he has got the
There is a
allotment?
complaint, because there is a complaint. Your
No, the
Lordship.
complaint has been addressed by the two verification report. In a way, it can be termed as an harassment also. One complaint gone, they say it is okay. And the second complaint, again, he says it's okay. Third complaint goes down to the DC. DC says, come. All of you come together, we'll discuss.
And
Why
more-
should he go?
And more so, Lordship, before the allotment is given to anyone, Lordship, any allotee, the survey and verification of the plot is done by the staff of the land management department. That
is why-
under the instruction of the deputy commissioner.
That is why one has to assume that this allotment was given after following all those formalities,
Exactly,
isn't
Lordship.
it?
Exactly, Lordship.
Is there any whisper anywhere in the report saying that this allotment has been made behind the back,
No, Lordship.
not as per the procedure?
No whisper, Lordship.
Then?
No whisper.
Yes, what else?
In the event, Lordship, if
Hmm.
even after the allotment, if it is found that there is overlapping of the map and all, then only, Lordship, this allotment can be cancelled. Otherwise, since there is nothing as
Ah.
such,
Power to give, power to cancel
Yes.
is there, definitely.
The section 21 of General Clause Act will cover power to rescind power to alter,
Yes, here somebody is pressing hard for cancellation. But
that is what, the entire proceeding is harassment. Prima facie, I see a nexus between the deputy commissioner and these two gentlemen, the complainant, only to harass. When the process was done, where you were? You were sleeping? And suddenly after 3 years, you come and look, this has done this. And that is the difficulty in the government affidavit. When the government advocate makes the submission beyond the instructions and what is stated in the affidavit. Therefore, this is perverse, it should be interfered. The whole proceeding should go. If they are agree, let them file complaint before the government. Government will further delegate them to examine. You cannot harass me in this manner. That's why, my lord, I respectfully made a submission. Any deputy commissioner or any government officer, my lord, they are there for the welfare of the people, not to harass the common citizen, my lord. After all, they are occupying that post because of our taxpayers' money. You cannot connive with somebody and harass me in this manner, my lord.
All right, Mr. Tara, we'll do one thing. We'll post this matter again. Day after tomorrow.
Correct.
Just examine the matter a bit.
Well, I'll also do some more research, my lord.
As straightforward is this matter again day after tomorrow. Give the date, 24th for admission.
May I please, Lordship. My lord, here, my lord, we are praying for consideration of the interim order, my lord.
Interim order.
Yes, my lord. This
What
is
is the interim order?
regarding tender, my lord. So, my lord, I'm one of the bidders, my lord. In the,
Pleadings have been exchanged?
no, my lord. My lord,
Why not? We don't. What is
We are
warrant number
yet to
5?
file our-
Warrant number 5 has filed.
Yes, my lord. My lord, the matter is, my lord, I am the second lowest bidder. Here, there's no dispute regarding that one. That the lowest bidder, my lord, he has withdrawn, my lord. And I'm the second lowest bidder. And the work has been awarded to the highest bidder, my lord, which is margin of more than 12 crores difference, my lord. And the NIT, my lord, condition that is there, it says the bid should be given to the lowest bidder.
Where is the interim order otherwise?
No, man, I'm praying for interim
Oh,
order.
you're praying for
Yes,
interim order. I thought you were praying for cancellation.
No. I'm praying
My
for
lord,
interim order.
Okay.
We will require some more time to file our affidavit.
lord.
However, my lord,
Ah.
it is not that how my elder brother is portraying. He was the second lowest bidder. The lowest bidder was one NT agency.
Hmm.
When the bids were financial bids were open, he first withdrew his EMD. He quoted 28% below. NT agency quoted 30% below the estimated cost. When the process for awarding was considered with NT agency, he withdrew his bid. In the meantime, after he withdrew his bid, NT agency also felt that he may not be able to proceed with the quoted price. He withdrew. Now, ultimate remain is the L3. When the work has been awarded to the L3, now he is raising that I should have been awarded. Whereas he withdrew first, he was the first one to withdraw. He knew that he is L2 and there is already L1. He withdrew himself.
Where, at what stage?
After opening of the financial bid.
Before, if you withdraw, then how?
No.
How are you
Yes,
proceeding?
after withdraw,
Let him complete my last.
All right.
after withdrawing,
I'll
there
just-
were 3 financially successful bidders, my lord.
Now, what was this bidding for? For what purpose?
Construction of road.
Construction of road. How many bidders?
Total 5 participants technically qualified. Then after that, 2 withdrew before the financial bids.
2 withdrew,
Yes,
including the petitioner.
No, my lord.
Okay.
Then remaining 3, their financial bids were open.
Okay. including the petitioner.
including the petitioner.
Then as per the financial bid, who is the L1?
L1 was one NT agency.
Okay,
Then petitioner MS Kaushik. is-
petitioner.
Kaushal Gautam, Kaushal Sharma.
Hmm.
He was L2,
L2
yes.
and L3,
L3 was private respondent MS Punahinda.
respondent number
3, respondent number 5.
five. So,
L1 quoted 30% below, L2 quoted 28% below, and L3 was on the estimated cost. This was the result. Now,
Hmm.
petitioner being the L2, he withdrew his EMD.
how do you say his withdrawal?
It is there.
Huh?
He withdrew his EMD.
How?
He has sent a
EMD earnest money.
earnest money.
Is there any material to show that
Yes, my lord, it is in the
withdrawal of the EMD?
yes, in the petition itself. After
Where?
at page 57. ये तो है ना? This is no 59 page. 59 page 59. No, ये 59 नहीं ना? No, no, clarification this. Page 56. No, clarification. They have not encroached. No, they have encroached.
59.
No, they had. I'm sorry, my lord.
No, 59 says, I have received your application
Yes.
for release of EMD and accordingly, I have taken action in favor of you and
My
sent
lord,
the same to you. through
that-
India
that-
Post.
Page 57, my lord will say.
Huh?
Page 57.
57.
Clarification on letter dated 7/3/2023 regarding release of bid security amount. They have not enclosed that. With reference to the above cited subject, I, Sri Kaushal Sharma, beg to inform you that the said letter release of bid security against the above mentioned tender work was submitted by unauthorized before your good office without my knowledge and consent.
Hmm.
In fact, letter was drafted by me in order to avoid inconvenience to authorized persons on my behalf or of my firm, as sometimes I frequently visit my work sites, which are located interior places where there is no network coverage. So my intention was to draft the letter and hand it over to it to authorized persons so that they may use it at the time of need when I am not reachable. Therefore, I request to consider and presume that the said letter was not sent and submitted by me.
Hmm.
That means that letter was there. It was on 7/3 withdrawal letter. After that, he's making a clarification. Pursuant to that withdrawal letter, EMD was released, my lord.
When?
This is 14th. Instructions 14th of March. 14/3. This was on 7/3.
See, 7/3 he has written.
Yes.
He says that it is not me who was written.
No, man.
It
He's not disputing that it was written by him. 7/3, he has written, and he's saying that it was to be used by authorized person. He has sent it. Accordingly, the EMD was released.
No, that's why it says it was State letter release of bid security against the aforesaid tender work was submitted by unauthorized before your good office
Yes.
without my knowledge and consent.
That means it was submitted. It was submitted, said letter, he is not disputing that there was no
Without
letter.
his knowledge and consent,
He had, it
Who
is,
sent
in- it is in his own signature.
in fact, letter was drafted by me in order to avoid inconvenience to authorized person. I have frequently visited my so my intention was to draft letter and hand over it to an authorized person so that it may be used at the time of need and when I'm not reachable. So he's prepared some draft
He
ready.
has signed it and it was submitted accordingly.
It was submitted by somebody, but he says that he was not authorized.
Yes, my lord.
So,
He's not disputing that, but whether it is the authorized one or not, my lord, it is in his own signature, it was submitted. Accordingly, the EMD was released. Now, after,
but at any rate, this letter is of 2nd of April.
no, my lord.
Yes, why
7th
not?
of, 7 March,
Correct. This letter is by the petitioner on 2nd of April.
7 March, my lord, and
No.
then,
No, 2nd April.
yes, 2nd April, this is clarification is of 2nd April.
Correct. And by that time, money is already withdrawn.
Yes, my lord.
That is
By
what
the
I'm
time,
saying.
yes, by the time.
Because
on
14 March, the money was released.
Release,
How it was released?
but it was released, sent by,
Through Indian Post.
yes,
How? Draft.
draft.
How it is released?
It was released by Speed Post, I think that EMD itself.
How much is the EMD? How was it released?
I will have, madam.
This letter says that I've sent it through in Indian Post
Yes,
from Itanagar branch. Means what? Bank draft,
by post,
Or-
it was sent.
earnest money is deposited in what form?
Earnest money,
It-
bank,
It is
draft,
deposited in what? Banker's check, what?
bank
how?
draft.
Bank draft.
Yes, madam. BG.
Where is the NIT? What does it say?
BG,
EMD.
format,
How does one deposit EMD?
EMD by BG.
There are also very many.
My lord, I think bank guarantee number also. It is not by
How?
draft.
That's why I'm asking you, because he said simply saying return means how it was returned. Because now the controversy is that he says that I have not taken back this.
No, that he has received, we have,
You said that he's applied for it and he took it back. That's why I'm asking you, how this bank guarantee or whatever EMD has been. The bidding document doesn't contain all these things. So what? Isn't it supposed to contain all these? These are the basic things.
bidding.
Earnest money, isn't it?
Yes, ma'am.
Column number 5 is earnest money. 37,63,800. But how it is to be deposited?
They have not included SVD, madam. It must be in the SVD.
Hmm?
Guarantee.
They are not-
So anyway, your case is that
Bid security. Bid guarantee.
earnest money deposit.
Yes.
When can it be withdrawn? Even before completion of the tender? It can
Yes,
be
ma'am.
withdrawn.
Even before it was awarded,
And if he has withdrawn it, then what happens?
he is out of the bidding process, my lord. Once he withdraws, he is out of the bidding process.
So money was given on 14 March.
14 March, it was sent. Then Thereafter only the L1 bidder, he also withdraws. Now, after coming to that, he makes a clarification that was not actually submitted by authorized persons, all this, but they are not disputing that a letter was sent seeking release of the earnest money with security.
L2 withdrew, that is the petitioner.
Yes,
L1 also withdrew.
after, yes, madam.
When?
After the petitioner withdraw. That
Why did they
specific-
withdraw?
That, as per instruction, it is on 24th of March,
L1,
21 or 24th, yes.
L1.
L1, after, that is after L2 withdraw.
No, since they are L1, L2, why should they withdraw? What is the reason behind?
That is, they have quoted, L1 quoted 30% below, L2 had quoted 28%
28% below.
below.
Wow. So that is beyond the permissible limit.
No, my lord, maybe the reason why L2 withdraw is not done, maybe it is because of quoting very low price, my lord. L3 quoted 30% below.
No, L3.
Oh, L1,
As
L1.
per the estimated cost.
L1 quoted 30% below.
Huh. So what is
Maybe-
wrong? What is wrong in that?
Yes, ma'am, maybe because of,
Unless you follow the CPWD manual, that variation limit is there, isn't it?
yes,
Up to what percentage above and below it's
yes,
permitted? Up to what percentage?
my lord.
10%,
10%.
20, 10%.
Yes.
Now,
But
if
they
it's,
were allowed.
if it's 30% below the estimated amount, then
It, even then, my lord, that's why there was no objection. Had they not,
there's no restriction.
no, had they not, we could have maybe awarded the work. Had them to the L1.
No, what I'm trying to say is that,
Yes, madam.
is there no restriction that
It is-
you are
there is.
supposed to quote within this range?
Yes, madam.
Because if they say 30%, 40%, 50%, then
Yes, madam.
what about the quality of the work?
That is also there, madam.
They will not,
Yes, yes,
they will not do the work at a loss.
exactly, madam.
It is nobody's charity.
Yes, madam.
They do that for profit. So if he quotes too low a price, then one becomes apprehensive.
Yes.
The work will suffer. How can he do such? So that is why that safeguard is there. It has to
Yes.
be within certain
Within-
limit. It cannot be too high also.
Too high also.
And these games are played in curtail in certain
Yes,
area also.
yes, madam. Up
This
to-
group
up
will
to
quote this
10%,
much.
There, up to 10, it's.
To elevate somebody, they'll quote this much and one person will be elevated.
Yes, madam, that.
That also is there.
Even up to 10% below or above,
Yes.
there also is that 5%, up to 5%, thereafter exceptional cases up to 10%. These are there in the CPWD manual.
All right, your case is that he has
Yes.
withdrawn.
With-
L1 also has withdrawn, L2 also has withdrawn.
Yes, madam.
So he cannot claim to
And.
stay at this stage.
Yes,
Whatever he has in the case may be examined as in due course,
yes,
but there is no ground for stay.
yes, my lord.
Correct.
And work was also awarded long time back, my lord.
When?
And my lord will see.
May 2023,
May.
Huh?
30 May, 30/05/2023.
30 May of 2023.
Yes,
ma'am. And as of now, madam, 4 kilometer formation cutting has been.
Okay. But then again, there are judgments also, isn't it? Somebody
Yes,
was
madam.
quoting
My
the
lord,
Nagaland judgment.
yes, NG Enterprises here also,
Ah.
NG projects that.
So measurement will be done, whatever work you have done, and
NG
he'll be paid,
projects,
and they'll call for a fresh tender.
Supreme Court
If the
judgment.
court finds that there's something wrong with the
Yes, my lord.
thing,
They're entitled for damages.
and he can be relegated, the party can be relegated for damages also.
Yes, my lord. I don't, this is a developmental work, my lord, and now he cannot play hide and seek. Well, he's not disputing that the letter of withdrawal.
Yes, Mr. Tafo.
Yes, Madam. I'm not said anything regarding that as such, Madam. Madam, this is a very peculiar case, Madam. Lordship is aware, Madam, in tender cases, Madam, it involves a lot of money, Madam.
Yes.
So what happened here, Madam, definitely it was already prefixed, Madam, this particular respondent should get the tender award. what happened here, man? Because I'm a contractor, I have works in the Vijayanagar. That's in the application is clearly written, man. In Arunachal, man, Vijayanagar is a part of our state, man, where there's no network, man, of mobile network. So it sometimes becomes very difficult to have communication whenever I go to project, man, that side. So what happened? I wrote a letter, this letter, in case I fail in this bid, man, my representative will deposit this letter with the executive engineer. Somehow, man, someone took a photograph of that one and WhatsApp it to the executive engineer. Man. I'm simple case in my let the executive engineer produce the original letter which they have received before this court. My case may be dismissed. Nobody ever deposited that letter before the executive engineer. The executive engineer has only the WhatsApp letter, not original. And after receiving the WhatsApp message, Malal, how they could have called me or my representative, which always was present in the bid, man. No one was called, Malal. Very secretively, Malal, the demand draft was put in a postal service, man. So that
Demand draft.
Yes, Malal. I have annexed it one also. This is the thing, Malal. Let the respondent of 4 produce the document, Malal, which I have deposited. I will have no case. Otherwise, I have not withdrawn, Malal. How being Malal, one of the lowest bidders, Malal, how I will withdraw from this bid? What happens, Malal, this gap between the 28% which I have bid in this tender, Malal. If I'm given, I will deposit equal amount of bank guarantee for that work. The alleged document, alleged withdrawal letter, Malal, let the respondent who produce that letter before this court. Nobody has submitted. Total connivance. Somehow they made the L1 to withdraw the EMD. Malad, then surreptitiously mine also in this manner, Malad, they have sent back the EMD through postal. Malad. It is always they, if they want to give it back, Malad.
So that's why now I think let them file their affidavit.
Malad, this is I
Clarifying the stand.
Yes, Malad. Especially Malad, the respondent number 4 need to file an affidavit, showing that he has the original letter which I have deposited with him. I have categorically stated, Malad, in my petition. Someone has WhatsApp that letter, Malad.
Okay, minus the withdrawal part, what is your case?
Otherwise, lots of all the and a bid, Malad, NIT also says it should be given to the lowest bidder. NIT.
But then again, there was another bidder who's lower than you.
Yes, Malad.
But it appears that he also
Yes,
withdrew.
Malad. If the lowest, but if he withdraws, Malad, it should be given to me, Malad. Not to the highest bidder. The difference is, I have said, 12 crores difference.
Well, we'll ask them to file affidavit. We cannot have an interim order now. I heard Mr. Pitafo, learned counsel for the petitioner. Mr. Titagum for respondent number 5. And Mr.
N. Ratan.
N. Ratan, learned additional AG for the official respondents. Stop. Next para. The grievance expressed by the petitioner in this writ petition is that he, being one of the lowest tenderer in the tender process initiated, provide the invitation for bids within bracket IFB dash turnkey mode dated. What is the date? dated nil.
It's published in Arunachal Pioneer on 13 November 2022, page 33.
Dated nil, which was published in the
The Arunachal Pioneer.
Arunachal Pioneer
Yes,
daily, dated 13/11/2020,
yes, 22, yes,
23 or 22?
22,
22
yes.
ought to have been selected for the work concerned. To stop. According to the petitioner, no, then full stop. According, Mr. N. Ratan, learned additional AG, on the other hand, submits that although the petitioner was amongst the successful bidder in the technical bid as well as in the financial bid, the petitioner withdrew the earnest money deposit by submitting an application on 7/3/2023. To stop. Accordingly, the earnest money deposit was sent to him on 14/3/2023 by post. To stop. Since the petitioner has withdrawn from the tender process, the present writ petition is not maintainable. The present writ petition is not maintainable. To stop. Next para. However, Mr. P. Tafo, learned counsel, submits that the petitioner did not withdraw himself from the did not seek withdrawal of the earnest money deposit. And the copy of withdrawal sent under his signature was without his knowledge and consent. And the same was only prepared by the petitioner in advance for use in any eventuality, since he has to visit the work sites located at interior places where there are no network coverages. Stop. He submits that a hard copy of the withdrawal letter was never sent. And in fact, somebody had sent the scanned copy of the withdrawal letter through WhatsApp without his knowledge and consent, which came to be acted upon by the respondent authorities. To stop. Next para. Considering the controversy raised, the respondents to How much time should he require?
2 weeks, my lord.
The respondents are given 2 weeks' time to file their counter affidavit and also to produce the relevant records.
Yes.
For perusal of this court. Full stop. Likewise, the private respondent may also file it.
He has already
counter
filed.
affidavit. Well, okay. Okay, likewise not required. List the matter again after 2 weeks. Obliged. Yes,
Respondent has to file the affidavit.
May I please, your lordship?
yes.
Lordship, our affidavit is ready to be filed.
How much? 1 week?
Yes. One.
As paid for a week's time is granted to the Learned State Council for filing counter affidavit. List again after a week. An interim,
yes.
interim order passed earlier to continue till then. Obliged.
May I please, my lord?
Yes,
My lord, my lord, respondent yet to file affidavit.
yes.
My lord, there are some extra copies today only, my lord. So we need some time, my lord.
Okay. How much time?
3 weeks, my lord.
Okay. Similar order, huh? Make it 3 weeks. Yes.
My lord, sorry, your lordship, as per last order, there was a direction to take fresh steps, your lordship. But that has not been taken. So I
On
may be-
respondent, steps to respondent number 5.
Yes, your lordship, that service report is still awaiting. I will take fresh steps, your lordship.
Service report awaited from respondent number 5,
Yes, your lordship.
but you are directed to take fresh steps.
Lordship. Wide order dated 9/2/23, your lordship.
All right, as paid for, petitioner is granted further 1 week time to take fresh steps
Yes.
on respondent number 5. List the matter again after 3 weeks.
May I send, my lord?
Rejoinder,
Pardon, my lord.
are you going to file rejoinder?
I have filed yesterday, my lord, but in the morning, at noon, my lord, I am informed, my lord, due to two documents, my lord, was not legible. Accordingly, my lord, I have changed that, my lord. I have filed yesterday, with them, but then maybe not on the record, my lord. I have served yesterday also, the other side also, my lord. I have filed.
So have you rectified?
Yes, but I have already.
When?
At
Today?
today, my lord.
So when do we list?
Otherwise,
Mr. L. Terme, Learned Counsel, for the petitioner submits that he has filed a rejoinder affidavit and has also corrected the illegible annexure. And has also filed the legible copy of the annexure, which according to the registry was not legible. Yes.
tomorrow, my lord.
Tomorrow, my lord, tomorrow, my lord, I have a football match, my lord.
Huh?
Tomorrow I have a football match.
Football match, where?
I would say, my lord, on day of 25, my lord. 24 also I have my child birthday, my lord. So 25,
You're coming with your family program here. Huh?
25, my lord.
So
2
court
days.
will, court will function according to your family program.
No, my lord, I am just praying accommodation by the other side, my lord. I am informing them, my lord.
Okay, Mr. Picha, then you have it next week then. Let him enjoy the football match and the birthday party.
28.
As paid for is the matter again next Tuesday. When?
29.
On 29th,
Yes.
And admission problem.
in the admission column.
Yes.
Yes.
Obviously.
Obliged.
Here, my lord. Here, my lord, our affidavit is ready, my lord. We need some time, my lord, to file it.
When can you file?
Within 2 weeks, my lord.
Then it's not ready. If it 2 weeks time is required, I thought you'll file during the course of the day or something like
No,
that.
2 weeks, my lord. Certain portion is left.
We have received the parallel comments.
Yes.
And you, others?
My lord, I'm appearing for respondent number 10, 26, 31, and 38.
Have you filed?
No lordship.
When will you file? Are you going to file?
Yes, lordship, I'm also ready to file, lordship. I need time, lordship.
And you?
I'm appearing for respondent number 19.
Both of you are private respondents?
Yes.
So all the parties are represented?
No, man.
Who's-
No.
who's not
Respondent number
represented?
22 is service report of the respondent,
Okay.
42
23.
awaited, my lord. 22.
So how much time should you require?
Letter may be released after 3 weeks.
3 weeks?
Yes,
When?
maybe 2 weeks, lordship.
If you're not sure whether 3 weeks or 2 weeks,
I need
okay, we'll grant you 2 weeks. All right. You file. Are you waiting for the government to file first or what? First, you'll wait for the government to file, then you will file. Is it like that? Depending on the reply given, you will adjust. Okay. Parties are represented by the respective councils, except for respondent number 22. Full stop. As paid for by the learned councils appearing for the respondents today, further 2 weeks' time is granted for filing counter affidavit. Full stop. In the meantime, let service report be awaited from respondent number 22. Any interim? No
Yeah,
interim.
I have prayed for interim in this.
But
case.
not granted, isn't it?
Not granted.
Okay, next time. List after 2 weeks.
All right.
Here also, my.
This is also for time.
Yes, my lord.
Is a new case?
Yes, sure.
How much time?
3 weeks, my lord.
As paid for by the United States Council, further 3 weeks' time is granted for filing counter affidavit. List after 3 weeks.
My lord, yeah, I'm appearing for respondent number 2, my lord. I may be given, my lord, 3 weeks' time to file a counter affidavit, my lord. We have not received the comments yet.
Who else are there? What about 3? Respondent number 3?
No, nobody is representing.
Because notice is not served till now.
Yes,
Who's respondent number 3?
private respondent, my lord.
What to do? Take fresh steps.
My lord. I, my lord, took step on my lord, on 6, my lord, 6 today. I
Okay.
think it will be, I will take restep, my lord, I think 6 is already June, my lord, on June I take.
But what about the address? Is it correct? What is the matter about?
Matter, my lord, my allotment, quarter allotment, my lord, has been allotted to other person, my lord, with this private respondent number 3, my lord, without cancelling my allotment, my lord. I am
What?
still at there, my lord,
Quarter allotment.
allotment, my lord.
Where are you? You are still occupying the quarter.
Yes, my lord. I'm without cancelling my allotment, my lord. They have allotted this person.
But is the address correct?
My lord, yes, my lord, should be, my lord. Address.
What is the CDA? Miss so and so. LDC, Public Works Department, CDA. CDA means what?
It's Capital Division, man.
Huh?
Capital Division.
Capital.
Capital Division
Yes,
A.
Division A, Division B is there, man.
Okay. But under which establishment? PWD, Capital Division A.
Yes.
It should have reached, isn't it? Otherwise.
But my lord, they should have given particulars of the address of the respondent, man. Instead of giving CDA, something like that.
That's what I'm asking you, Mr. Perme.
My lord.
Why don't you find out? Where is the allotment?
Allotment order, my lord. Mm.
Page 27 is that.
27, my lord.
Now, it's here, it says library office in the allotment order.
No, my lord, this is, her address, my lord, will find it page 27, but down below, my lord, copy to my lord, page not 27, my lord. This librarian is me, my lord.
Oh, sorry, 27.
My lord, P kept a copy to my lord, executive engineer CTA Itanagar, my lord. This is his address of my lord. In the allotment order also, my lord. Copy to my lord, PWCTA Itanagar. ADC PWD Division A Itanagar, governmental program, PWD.
So what to do? You take first steps or we wait for the outcome of this? How many times have you taken steps?
It almost 2 months, my lord.
No. How many times have you taken steps?
One time, my lord.
Once only.
One.
Take one more.
I will, my lord. I will.
All right. It seems that it is seen that the respondent number 3 has not been served. We'll stop. Mr. L. Perme, learned counsel for the petitioner, shall take fresh steps to serve notice upon respondent number 3 by registered post with ADD within 3 days. This is the matter again after
3 weeks.
3 weeks. The respondents to file their counter affidavit in the meantime.
Interim, my lord, is definitely come.
Interim order passed earlier to continue
Obviously.
till then. It is also service report awaited.
My lord, I'm appearing for the private respondent.
Number
By today itself, I file wakalat number on behalf of private respondent number 4 and 5.
4 and 5. Good.
I need some-
Your good name?
B Kamdak,
B.
B Kamdak.
Mr. B. Kamdak, learned counsel, submits that he has instructions to appear on behalf of respondent number 4 and 5. And that he'll be filing his power during the course of the day.
Yes.
Full stop. He further submits that he may be given how much time?
4 weeks time.
4 weeks time to file counter affidavit.
Yes.
Stop. Similar prayers made by Miss
T. Wangmo, madam.
T. Wangmo, learned senior government advocate,
No, madam, government advocate.
learned government advocate, appearing for the official respondents.
For petitioner, my lord.
Sorry,
Petitioner. T. Kamchi.
Mr. Okay. List again after 4 weeks. Any interim?
Yes, my lord.
Yes.
List again after 4 weeks. In the meantime, the interim order passed earlier to continue. Your name, Mr.
T. Kamchi.
Tamche.
Hmm.
Presence of Mr.
T. Kamchi.
T. Kamche is put on record. Yes.
Most obliged.
Much of my lordship.
Hmm. Yes.
Lordship, government has to file affidavit.
Lordship, they have not furnished any extra copies to us till now.
Okay.
No.
You give extra copy.
So sorry, Lord.
And
I
number
will
2,
pass the-
what about respondent number 5? There is no service report.
Lordship, I will take these steps within 2
Okay.
days, Lordship.
Fresh steps.
Precisely.
All right. As paid for by the learned state council, further 3 weeks time is granted for filing counter affidavit. The learned counsel for the petitioner to provide extra copies of the writ petition to the learned government advocate within 2 days. Full stop. Since respondent number 5 has not been served, the learned counsel, the petitioner to take fresh steps by registered post with AD for service of notice upon respondent number 5. List the matter again after 3 weeks.
Lordship, there is interim order, Lordship.
Interim order passed earlier to continue in the meantime.
Obliged.
May I please, Lordship?
Yes.
So we have taken the steps on private respondent and notice has been served to the others.
Here, my lord, I am yet to serve with extra copy, my lord. Extra copy. And
You are for?
I am for the official respondent, my for from 2 to 7, my lord. As a standing council power department.
2 to 7. Who is 1?
State, my lord.
Yes. What is your submission?
Lordship, one is chief.
It has come back. Notice has come back. Unserved.
The council is unaware regarding that fact.
Huh? You're not aware about that?
Yes, my lordship.
It says unserved notice in respect of respondent number 8 is returned back to this registry with postal note refused through telephonic talk. What is this? Just check up the correspondence or second file. Has it come back? Some envelope is there. Refused through telephonic talk. What is the case about?
It's a service whether related to promotion.
Which post?
As an electrician in an electrical department.
Oh.
So my client is a senior employee. So in place of him, a junior who doesn't have enough qualification has been promoted. So
Respondent number 8.
Yes,
8 has been promoted.
yes.
Okay.
Yes, my lordship.
So, Mr. Perme, what to do in such kind of situation? He is refused.
My lord,
Refused through telephonic talk. How is communicated through telephone? The postman gave telephone call over. I'm coming to your house. He says, don't come. It's like that. You take fresh steps again. All right.
Yes, my
You
lordship.
take back this one and take fresh steps.
Okay.
Parties are represented by the respective councils except for respondent number 8. To stop, Mr. L. Perme, Learned Standing Council, Power Department submits that he has not received extra copies of the writ petition. Stop, petitioner to furnish requisite extra copies of the writ petition within 2 days. To stop, Ms. R. Basar, Learned Government Advocate, submits that respondent number 1 will not be filing counter affidavit. Next para. As for respondent number 8, office note dated 19/8/2023 indicates that the notice sent to respondent number 8 has come back with a postal note, open inverted comma, refused through telephonic talk, 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 close inverted comma, full stop. Next para, in view of above, petitioner to take fresh steps for service of notice upon the respondent number 8 through registered post with AD due within 3 days. To stop, the petitioner is allowed to take back the unserved notice and writ petition which has come back from respondent number 8. Okay, you take back this one, put a fresh envelope and send it again. We'll see if it comes back like that, then we'll see what to do. List the matter again after 3 weeks.
Deeply obliged.
My lord, business for the implementing the party.
Item 24.
Yes, my lord.
What about 23?
23, 24 is one is IA and one is.
Oh,
main.
23 is that already?
Yeah.
Motion, okay.
So my lord, I'd like to request the matter maybe fixed for tomorrow so that.
Why? Why not today? This is the last item. You've got 1 hour to argue.
My lord, I want to-
Tomorrow you might not have time.
my lord, I would like that. Like to enter case of the.
Okay. You are for the petitioner and you file IA also. IA for what?
For completing party.
Impleading.
Right,
And you are there?
my lord, in this matter, I am representing in writ petition respondent number 4,
Who is that?
Director Urban Local Body. The
Director-
office has already been impleted otherwise. And the direction incumbent director has been made, the petitioner is trying to implement the incumbent director in person
By name.
by name.
Okay.
So otherwise it is, in my humble understanding, it is not required since the office is already, because dispute is with regard to the
So-
creation of the post only.
So you are for respondent number 3.
No, 4.
Oh, sorry, respondent number 4. And remaining respondents, you are there. Any affidavit filed?
Yes, ma'am.
You have filed affidavit. Now, what is the controversy here?
They want to impede, madam.
No,
My,
input is
my
something.
lord,
What is the subject matter?
Basic thing is that the
Use the microphone. Microphone.
oh, my lord, the department, urban local bodies,
Yes.
which is a new department,
Ah.
is a department of one body of director, a department of director, town planning and urban local bodies, which is gazette notification clearly made and fully authorized. And present department, which is created as urban local body, has been not made with a due process, without with administrative approval, and without any authority. This is the challenge challenge in the petition 484. So that is why I said the matter may be taken up tomorrow, so
No.
that I may come with
Okay, that's okay.
a purpose.
You are saying that the post of director,
Yes,
urban local bodies has not been created
not created.
in
My lord,
accordance with the,
my lord, not been created. Not only the director, the entire the department, the new department.
what is the new department?
New department is urban local body.
Urban local body.
Yes, my lord.
Okay. What was the name of the department earlier?
No, that is my lord.
This is the first time.
Yes, that is Department of Town Planning and Urban Local Bodies, which has been gazette notification with the authority of gazette notification. It is
Just-
still
Just a minute.
functioning.
Department of Town Planning.
Town Planning and Urban Local Bodies
Town Planning
and Urban Local Bodies.
and Urban Local Bodies.
Yes, my lord.
Now, this department is no more.
No, it is
Still there.
it is in existence.
It is still there.
It is still in existence, and the note with the authority of gazette notification, it is functioning. But without superseding or without subsequent notification, this, in spite of existing this department, they have created one department that is called urban local bodies, and that is also without administrative approval, guidelines,
But-
RR,
Okay, but the name is not.
cabinet approval,
The name is not a department. It says body.
urban local bodies.
That's why. So can it be considered to be a department?
No, it is my lord, what
Urban
I said.
local bodies.
Urban local bodies, Department of Urban Local Bodies. Under the town planning, Department of Town Planning and Urban Local Bodies, it is already covered, but they have created another department called Urban Local Bodies. So that is why I am,
Correct.
yes,
See, I understand.
yes, my lord.
There is already a department of town planning and urban local bodies.
Yes, my lord, exactly.
Now, they have again created urban local bodies.
Yes, my lord.
But my question is this urban local bodies a department
Yes, my lord.
or it's only a branch of that?
No, it is a department because they have the different separate director.
my lord, may I intervene for the better understanding? My lord, earlier there was this urban local body and the town planning. They were in the same department.
Okay.
Basically, the urban local body, the directorate urban local body were being these duties are being assigned to the director town planning. Now, what happened subsequently? What happened? This urban local body director was the nodal officer. Director TP was acting as also acting as a director urban local ULB urban local body. What happened due to administrative exigency and the workload? That urban local body has been bifurcated and created separate department. Now the petitioner is challenging that creation of that separate department.
Okay, now what remains with the earlier department? Town planning.
Yes. Now, basically, town planning, it was nomenclature was town planning and director town planning and ULB. Now, what happened after creation of this ULB department,
Yes.
separate department? Now, town planning is only town planning.
I see. There's
And
no
then-
more, there is no more urban local bodies.
Yes.
So this the earlier department has is bifurcated,
Yes, by far.
town planning one side and our local bodies one side.
Yes,
This
yes,
is-
yes.
This is the practical thing that is happening, but as per the official authority by, that is in the page number 34, the gazette notification dated 18 June 2010, the authority is given to Department of Urban Town Planning and Director of Department of Urban Town Planning and Urban Local Body is one as per this gazette notification, and they have been fully authorized by virtue of this gazette notification, and that this gazette they have separated the new urban local bodies without
All right.
superseding the present gazette
Alright.
notification.
That is one thing, but the other thing is that why do you want to have implement the director in person?
My
What
lord,
very-
my
why-
lord,
why?
there is
You're
one,
not against the director, isn't it? In person.
yeah, in person, I'm not against.
Then,
My lord,
then why do you want to implement him by name?
my lord, there are many directors comes up and goes within 2 months, 1 month. So that is why
That is why
in the
it's
earlier
difficult.
occasion, in
So
the-
every 2-3 months you'll have to change. Now Mr. A is there, now tomorrow Mr. B has come, he also implement. How long will he implement?
no, my lord, in my petition, first in the instant, I have already I have made as a director urban local bodies. So the honorable court has said that because there's a frequent changes of directors. So by name is better. So that is why I have specifically all mentioned the particular names, because one officer goes from here and that other goes, and if I am to find out who has issued this order, then the particular officer name is better to function and understand.
I don't know how far.
My lord, in that situation, tomorrow if director changes, then it will goes on, keeps on going. And
Correct.
there will no stoppage because
It is
because
the
you-
other way
it-
around. It is the other way around. See, instead of implementing a person by name, if you just say director, you need not do anything. So long as the directorate remains, director will remain a director.
yes, which is already there in the.
So only in
my
some
lord-
cases when there is
My lord, I have
malified,
no,
when there is malified, some specific allegation against a person. Then you implement by name, like supposing in a contempt petition also. If you just say director, we don't know which director.
yes,
So
my
you
lord.
have to implement by name. But in a writ petition, normally you don't implement by name. Subject to what you have to say in the IA, will hear you. You say, since you say you're not ready today.
My lord, I have no difficulties in giving us a just director. That is been already given, and certain other authorities are there which I would like to implement. So that also I have made by name, that also can be altered, changed. I have I'm ready to modify it.
Rest of the person whom the petitioner is trying to implement is also represented by the government only. The secretary, the under
My
secretary.
lord, my lord,
I
that
I
means
don't understand why it is necessary
don't
for
know,
the
he's
petitioner to
interested.
include those person in name.
my lord,
Secretary town planning also by name you should implement.
because secretary town planning, I have name given by name.
Chief secretary also by name implement.
No, chief secretary is not by name.
You should implement since you are interested by name.
No, my lord, secretary town planning, I have secretary town planning, secretary administrative reforms. I have all this by name. I have.
So when?
My lord, tomorrow.
Tomorrow
My lord, I have not been served with the copy also.
of the IA.
Yes. This came up for the first time today, but I was not served with the copy
Serve
also.
the copy.
It was filed, so if it is, I'll serve the copy also.
How did you file? Senior government advocate has received. Government advocate received, but the respondent, this Department of Town Planning, urban local body is not given.
And
Give
you
him a
will
copy.
Okay, my lord. Today itself,
Okay, list the matter again tomorrow as paid for by the council for the applicant stroke writ petitioner. We will, a copy of the application be served to Mr.
T Omo.
T.
Omo.
Yes. Honored council is paying for respondent number
4.
4.
Director ULB.
All right.
release the matter tomorrow. I'll serve today.
Yes, I have passed the order.
Okay, most obliged.
Give him a copy.
Okay, my lord. Most obliged. Most obliged.
Yes.
Obliged.
And